May it please your lordships.
Yes.
Not virtually I am mentioning this item number 5 to 9.
Yes, what is the reason?
In fact, other side represented by Mr. S.K. Kayal, we have agreed, my lord, this matter may be fixed on 29th of June.
Okay, with consent of the other side, the Learned Counsel for the petitioner prays for adjournment. Prayer is allowed. List on 29/6/2026.
Lord, the earlier interim orders will continue. Lord.
What is the interim order?
Interim orders are there in all the cases.
No, what is the nature of interim order?
My lord,
What is the nature of interim order?
interim order is, my lord, sort of status quo. Status quo. My lord, it's a matter pertaining to GST.
Yes.
Our case is the Arunachal authorities have no jurisdiction, number one. And considering the nature of the transaction, the tax is not payable at the in the state of Arunachal Pradesh. It is being payable in the state of Punjab
But
and
now,
Maharashtra, which you are paying.
But now recently, Supreme Court has given a judgment that if it is gaming
Yes,
and
my lord.
others, then these respective states will have to have the authority to charge.
My lord,
The Supreme Court has now held that the respective states would have the authority to charge.
no, my lord, it's in case of lottery, this is not the position. In case of lottery,
Okay.
my lord, no, Lord, this matter was hesitated. Thereafter, this order was passed.
Okay, interim order passed earlier stands extended till the next date of listing. Okay.
Deeply.
Malad, in this matter, Malad,
Huh?
state government has to file their affidavit, Malad.
State government.
Yes, Malad. Our part
it is their wisdom. They have not made a prayer. Maybe they are in. They want to give a walkover to the other side. We don't know.
Malad.
They must make a prayer. Unless they make a prayer, how can the Sumo give that time?
Well,
Deeply obliged.
My lord, if I may be allowed to mention item number 27, my lord. I am for the respondent number 3. We are supposed to file additional affidavit. My lord, we are filing in the course of the day. So my lord, may I kindly have it after 2 weeks for final hearing.
27.
Yes, my lord.
27.
We have to file additional affidavit, my lord. We are filing today itself in the course of the day.
Okay, why at this stage of hearing you want to file an additional affidavit?
The additional affidavit is, my lord, regarding to the status of the project, my lord.
Okay. Both sides are represented on the prayer made by Learned Counsel for the petitioner.
Respondent, my
after
lord.
2 weeks.
Respondent number 3, my lord.
Or respond number 3.
Yes, my lord.
Okay, respond number 3. List after 2 weeks.
May I please, Your Lordship? Your Lordship, I beg to mention item number 20, Your Lordship. In this matter, Your Lordship, we have filed our affidavit, Your Lordship. Your Lordship may kindly fix this matter day after tomorrow for admission hearing, Your Lordship.
You have already filed it.
Yes, we have filed, Your Lordship. That's why, Your Lordship, for admission hearing. Since tomorrow is the DB day, Your Lordship.
Okay. Both sides are represented. The Comment Advocate submits that affidavit in opposition has been filed on behalf of the respondents.
Yes, Your Lordship.
Which is not on record. Next, that the said affidavit be tagged with record. List on day after tomorrow. We'll get
Day after tomorrow, Your Lordship.
10.
10.
Okay.
Obliged.
Since I am the petitioner counsel in this petition, Your Honor, and an order has been already passed on 6 June, Your Honor, and the matter was listed on 3 for endeavor hearing, and the same nature of case was set aside on April, Your Honor. So the matter was listed for disposal of the writ petition, Your Honor, on 3, but the matter was not heard. So kindly the matter may be taken up today, since Your Lordship, there is a new development in the case. that after filing of, after,
You want us to hear the matter without the affidavit?
no, already,
Your Lordship,
already affidavit has been filed and all the three
It
respondents have
is
been
not on
served.
record.
it is not in the record
Then
obliged, Your Lordship. One more, Your Lordship, one more adjournment, Your Lordship. Item number 26, Your Lordship, of hearing.
pardon me,
Item number 26, Your Lordship. 26. In,
26.
yes, Your Lordship. In this, Your Lordship, Mr. S. Tapin, he is the conducting counsel, Your Lordship. He is for the petitioner, Your Lordship. He has some difficulty today, Your Lordship. Your Lordship, may kindly fix this matter on 15, Your Lordship. On Monday.
We'll take it up day after tomorrow. Review petition of 2018 is pending. Day after tomorrow.
Your Lordship, day after tomorrow. He might have some difficulty, Your Lordship.
Okay. Both sides are represented on the prayer made by learned counsel for the petitioner. List on. Make it next Monday. Okay.
Deeply obliged.
May I please, Your Lordship? Lordship, I beg to mention item number 17, Your Lordship. Lordship, as per the office note, Your Lordship, steps has not been completed upon respondent number 3, Your Lordship. Lordship, may kindly give us some more time to take steps, Your Lordship.
On respondent number 3,
3, Your Lordship.
just get that record.
My lord, in attempt 17, I am for respondent number 2, my lord.
Okay. Both sides are represented. As per office note dated 6/6/2026, though the AD card in respect of respondent number 3 has been received, there is no signature of the recipient. Next para. According to while the petitioner is entitled to take fresh steps for service of notice on respondent number 3 by speed post with AD, the registry shall shall take steps within 2 days for service of notice on the respondent number 3 by speed post with AD. The notice is made returnable on so and so. Give a date after 4 weeks.
Lordship, date may be fixed, Your Lordship.
She will give.
Lordship.
Next, in the meantime, the registry shall call for the postal track report for service of notice on respondent number 3. Next, the registry shall also call for a meeting with the who is the CGC here today? You're there?
17.
Yes, sir.
17.
Yes, my lord.
We are directing the registry to have a meeting with the postmaster general of Itanagar. This cannot be excused. Sending the AD card without signature. That means the process of the court is invalidated not just because of the lack of the authorities to follow the procedure.
Yes, my lord. In most of the cases, my lord, it happens, my lord. Without, my lord,
No, that's why we are passing a judicial order.
my lord.
We'll ask have a meeting and then ask the head of the authority of,
My lord, in all the cases, my lord, it is happening. That,
we'll
my lord,
take care of that. That's why.
Yes, my lord.
That's why we are requiring your presence.
My lord. Addressee are also available, my lord. Sometimes my lord, the mentions that addressee is not found available, my lord. That is
But that's
also, my
okay.
lord.
If it is not
Yes.
found, they will.
But we know, my lord, that they are very much residing there in the address given in the petition, my lord.
In Arunachal, who is the head of the postal authorities?
My lord, I'm not much aware, my lord, but the director, my lord, director of postal must be in the head office at Itanagar.
Shall have a meeting, the registry shall call for a meeting with the head of the postal department in the state of Arunachal Pradesh. As it is seen that the process of the court is being invalidated just because the postal authorities do not perform their duties as prescribed. Next paragraph. We also direct the head of the department of postal department in the state of Arunachal Pradesh to file an affidavit to inform the court about the steps taken for assuring the court that postal process sent through speed post with AD shall be duly returned with an appropriate postal remark, and if it is served, the acknowledgement cards should be legibly signed by the person who is receiving it. Next para. At the request of the court, at the request of the court, Mr. M. Katul Leonard, CEC, has appeared, and we request him to also send a downloaded copy of this order to the Chief Postmaster General, Northeast Postal Circle, Shillong, and also to the head of the Postal Department in the state of Arunachal Pradesh. Next para, we expect the affidavit to be filed within a month from the date of the order. Next para, the order should be brought to the notice of the registrar of the Itanagar Permanent Bench to take follow-up action. Next para, list the matter again on, give a date after 4 weeks.
My lord, my brother, my lord, copy me, my lord.
Ah.
My lord, it is DSCA, my lord, deputy solicitor.
She'll give it to you.
20 July.
We have otherwise permitted to send a downloaded copy of the order. So
Lordship, similar
therefore-
prayer for item number 18, your lordship. Here, steps is incomplete upon respondent number 4 and 5.
4 and 5.
Yes, your lordship.
My lord, in item
Okay.
18, I'm for respondent number 2 and 3. In item 18, my
Yeah,
lord, I am
for-
for 2 and 3, my lord.
Respondent number 2 and 3. Okay. 4 and 5. Okay, all
2 and
the
3.
appearing sides are represented. On the prayer made by learned counsel for the petitioner. 2 days time is granted to take first steps for service of notice on the respondent numbers 4 and 5 by speed post with AD. The notice is made returnable on so and so, list accordingly. Okay.
Deputy Clerk.
May I, Your Lordship? Your Lordship, I beg to mention item number 11, Your Lordship.
Yes,
This matter to be listed on this coming Monday, Your Lordship.
you have taken consent of the other side.
Yes, Your Lordship.
My lord, my senior is not able to come here, so my senior asking listed the matter next after 4 weeks. So today, my lord, we are going to file the affidavit in reply, my lord.
No, no,
So my humble submission is, my lord, listed the matter after 4 weeks, my lord.
Apin sarkar ko agent ho gala na.
Okay, both sides are represented. You are filing an affidavit,
We have already filed, Your Lordship.
already filed.
Yes, Your Lordship.
Okay. On joint prayer made by learned counsel for the petitioner and the learned government advocate. List on, give a date after 4 weeks.
20 July.
Okay.
Obliged, Your Lordship.
Always.
By the time we hear the matter, your matter would become infructuous.
Lordship, may I? Lordship, in terms of order dated 4/12/2025, we have already filed rejoinder on dated 29 January 2026. Lordship, pleading is completed.
In which item? You are referring to which item?
Pleading is completed, sir.
You are referring to which item?
Yes, Lordship, item number 15. Sorry, apologize.
15. Okay.
Yes.
So,
Lordship, in terms of dated 4/12/2023,
it's okay. We understand. Pleadings
Okay,
are
okay,
complete.
okay.
Then what?
my learned senior counsel, he is out of station. So,
You want an adjournment.
yes, my,
Okay. You're taking consent of the other side.
yes, sir.
Have you taken consent of the other side?
No, sir. No,
No, then wait.
State matter.
Then wait. We can't adjourn without the information to the other side. Correct.
Yes.
Supposing you wait for the entire day today, and then you find out your matter has already been adjourned, will you like it?
Yes.
Then same courtesy should be shown to others. Okay. You renew the prayer when the matter is called.
Come for the other side matter.
It's okay. We are not adjourning it right now because the consent is not taken.
Item number 1.
yes. My lord, may I please?
Yes.
My lord, I am APCS officer, SG. My lord, in select, SG means a selection grade. If DPC seats,
Your new place of posting?
my lord, I was posted in Daporijo.
No,
Yeah,
the question
Daporijo. This is annexure number.
In your new place of posting, have you joined?
Yes, yes.
Where is that?
The joining report. Joining report is page number 21.
21. Then we'll have to state, Mr. Nawab,
My lord.
we'll have to state within 13 days, you can't be transferred.
My lord, till returnable, there so that you can produce before your lordship the records, my lord.
Yes,
Then
yes.
final disposal may be done, my lord. Because it's a transparent posting, my lord. I don't do
I
any.
understand, but
Area, my
13
lord.
days. What is sir?
After
Your name.
Tadu Tamin.
Kadun Tabin, then counsel for the petitioner.
Thank you. 3 weeks. Hey. Okay.
You said Tagum Tamin. But take care of your clerk. Take good care of your clerks or your
Wakalat number.
or counting. No.
Then
Here he is written just
something different.
Actually,
Bayor, my lord, is a Bayor.
my lord, earlier it was written,
but
but
you take good care of your clerks, this will happen.
I have corrected my certificates. My that bar certificate has been corrected by Bar Council of India Guwahati.
Still, you see, your name must match here. No, in the first page, first order sheet. No, I don't see inside. I see the first page.
First page, my lord. Kitamin.
Tamia or something.
Tamin.
Actually, spelling mistake.
Spelling mistake.
What will be? I go by this one. That's why I said take care of your clerks.
Something.
I don't know. From the registry, I think it is written by.
No, registry doesn't like this page. This page is always written by the
Advocate's
N
must be, my lord.
N looks like A.
whatever be, but take care.
Yes.
Counsel for the petitioner. Next, by as well, I also heard Mr. R.S. Navam, the additional advocate general for the state.
I'll be for 1 and 2, my
Hearing
lord.
correspondent number 1.
1 and 2, my lord.
1 and 2.
Yes.
Next.
3 from local MLA, then 4 is
Performance.
The case of the petitioner is that by an order dated 19/5/2026 within bracket annexure A, bracket goes, he was the petitioner who is in this page 19, where is your name?
serial number 2, my lord.
Okay. The petitioner who's an APCS within bracket SG officer had been transferred as in charge ADC Daporijo TO2, in charge ADC Kepen GEPN. And accordingly, he had joined his new place of posting on 28/5/2026, for which reliance is placed on the joining report issued by the Deputy Commissioner, Kamle District, within bracket annexure B. Full stop. However, within 13 days of his transfer order, the petitioner has once again been transferred by an order number PERS-12/3/2023 dated 2/6/2026, issued by the Chief Secretary, Government of Arunachal Pradesh. So accordingly, the said order of transfer has been assailed. By filing this writ petition under Article 226 of the Constitution of India, if you notice returnable on so and so. How much time, Mr. Nawam?
My lord, since two private responses are there, one is local MLA, another my incumbent, my lord. So, my lord,
4 weeks?
4 weeks. My lord,
They'll have to be served
4
notice.
my lord, yes.
Give a date after 4 weeks. Returnable on so and so.
20 July.
The petitioners shall take steps in course of the day for service of notice on the private respondent numbers. And 4 5 post ready. Next paragraph. But both sides on the prayer for interim relief. So the London Additional Advocate General has opposed the prayer for any stay as regards the transfer and posting, which has been made for in public interest. As the petitioner has been earlier transferred on by an order dated 19/5/2026, and he has joined the place of posting on 28/5/2026. The second transfer order dated 2/6/2026, having been made within 13 days of the earlier transfer, the court is inclined to stay the said transfer order number page 22, number PERS 12/3/2023, dated 2/6/2026, only in respect of the petitioner whose name appeared at serial number 1 of the said list, without affecting any other transfer order. So the stay would operate till the next date of listing. Next paragraph, list on so and so. Next paragraph. Before that, you said that petitioner shall produce a certified copy of the order before the Office of the Chief Secretary, Government of Arunachal Pradesh, to bring the order to the notice of the said authority.
My lord, is it till returnable date, my lord?
Till returnable date.
My lord.
Item number 2 and 3.
Yes.
Well, the brother Tagum is stuck in a traffic. He has requested
After some time then.
for Passover, Milad. Grateful.
Fair.
Item number 10.
Yes.
Your Lordship,
Your Lordship,
we will.
Your Lordship, I appear on behalf of the petitioner.
Yes.
I mean, led by Miss Gini Rautri. Yes, she just switched on.
Please, my lords. My lords, in this matter, we have received the response, additional affidavits of both the respondent number 2 and respondent number 3 and 4, your lordships, in this matter. Respondent number 3 is the superintendent of police, your lordships, and they have categorically stated that a mob of over 300 people had assembled when we tried to carry on our work. despite court orders of 5th of February, Your Lordship.
Xerox करना पड़ेगा भाई वहाँ
Yes.
अब तो हो रहा है रुको उसका बाद। इसको- आई-
Yes. What is the difficulty in allowing the industry to function?
Here, my lord. This matter may pass over for time being, my lord. Here, N. Ratan is appearing, my AAG is appearing, my lord, and he's stuck in traffic. my
You
lord.
want for timing? Okay.
Yes, my lord.
Okay. She's praying for a
Please.
short accommodation. The additional AG is in the traffic jam. After some time.
Yes.
Please.
Item number 4.
May it please your lordship. Your lordship, the item may be passed over for the time being, your lordship. The council is in legs in courtroom number 5, your lordship.
Okay. Time being.
My lord, in this matter, my lord, I am appearing on behalf of respondents, my lord. My lord, I need some accommodation, my lord. It's because, my lord, there's so many law points are involved, my lord. And the sports court, my lord, my lord, the other things, my lord. So, it's my lord, the accommodation on any other appropriate date or within this week, my lord. Just to clarify, it's
Is in legs in courtroom.
no, it's okay. Well, in fact, one solemn Tana has been reflected. I tried my best to locate him to consult, but I did not find him. So
Okay,
because
but
of that,
he's been removed from service.
yes, madam.
Yes, your lordship.
So
Affidavit has been filed, madam. Everything has
it's
been
okay, but we'll have to give a short date for hearing.
Madam.
When?
Any
Your
appropriate date, madam.
Council is in legs. He has come from Guwahati in courtroom number 5.
Okay, just wait for some time. Let him come.
Deeply obliged, your lordship.
Item number 12.
There are another petition, writ petition 596 of 2025, which has not been listed. And in this case, the petitioner was supposed to file affidavit in reply, my lord, as per the last order. So now today, I think.
There
was a termination of service.
Termination of service, my lord. Actually, the appointing authority was Deputy Commissioner. We have taken one preliminary objection. Deputy Commissioner has not been made party, my lord. Admittedly, he was the appointing authority, my lord. Page 26 of the writ petition, my lord.
And how the second case is related to this?
The similar matter, my lord. With regard to the different.
No, similar matter does not mean that both should be taken up together. Because if one matter is decided,
that will decide the other matter also, my lord. So, my lord, the appointment order was a page 27, my lord.
I think it is my case. Let me argue then.
Actually, I would like to take a date now, since you were
No,
not
no,
filing
it's,
affidavit in reply.
My lord, I believe affidavit in opposition, rejoinder is not required in this case. For the simple preliminary objection which they have raised, the Deputy Commissioner has not been made as a party, my lord. Here, what had happened is, my lord, the FCI has requested, my lord will see this. My lord, just the fact is, the FCI has requested the state government to appoint Chowkidar or MTS in the security guards at the FSD depot at various districts in Arunachal Pradesh. Now here we are dealing with Dapur Regiment. Then what had happened, Manoj, on the request of the deputy, FCI, the Deputy Commissioner simply gave the appointment order saying that, see, your services will be placed at the disposal of the FCI because they are paying it, my lord. The FCI is directly paying.
But you see the statement made in your writ petition.
Correct.
Just come to paragraph 8.
Right. One second. Correct, my lord.
So now the security cover of so and so. Therefore, if it is security, it is something like a special police officer appointed, or he may be a home guard or something of that sort. And therefore, in the appointment order at page 24, it says no right to claim regularization or absorption of service in future. FCI may terminate his service at any time if his service is not felt necessary.
No, there's that proposition, that the fact which is falling from my lord, I am not disputing on this, my lord. The fact remains that, my lord, they have come out with one ground. First is the non-joinder of the parties. We don't have any grievances against them because against the Deputy Commissioner Dapurija 1. Number 2, my lord, there is a judgment of 1983, my lord, is aware, Janardhan Reddy, Janardhan case, wherein the apex court has categorically held that if the relief is not sought against the third party and whom it has been not implemented, then that will not be fatal to the maintainability of the writ petition. I have this authority. Second aspect is that, my lord, since the Deputy Commissioner was only facilitating, per se, there is a word called conduit, my lord. Well, just FCI requested me, I gave the appointment, my lord. Then thereafter they are paying us and they have allowed us to continue for 1 year only our appointment was done, my lord. Then they allow us to work continuously from 2016 to 2025, my lord. Now OM which my brother is referring to is, my lord, 11 something 2005, my lord. So in violation of that particular OM, they have requested the Deputy Commissioner Dapurija to appoint us, my lord. So now they are stopped from taking the shelter of this particular OM, my lord. My lord, my younger brother is suggesting me that if I can request my lord to take another matter along with this some other time, and if required, we will file the rejoinder. Which is the another number?
596.
596, my lord. Same cause of action.
Yes,
My lord, my
this thing is
preliminary
coming from
contention
outside.
was that the Deputy Commissioner is the necessary party to effectively adjudicate this present matter, my lord. So admittedly, he was the appointing authority, my
You
lord.
see, that
No.
will depend on the
And we
wisdom
used
of the petitioner. If the petitioner does not want to
Yes,
impeach
my lord.
somebody,
Yes, my lord.
Correct.
we can't possibly impeach someone and change the contour of the writ petition.
Yes, my lord.
My lord is correct because non-joinder should not defeat the substantive justice, my lord. That judgment is there, 1983.
No, it would.
Yes, 6.
Non-general necessary party is fatal.
Fatal, yes.
And there are a lot of orders even passed by me on the point that if the authority who is required to be joined and not joined, then it is fatal.
Here, my lord, Deputy Commissioner, in the official letter.
It's okay. We are not adjudicating it before hearing.
Correct, correct.
So it is your wisdom if you want, don't want. So, Mr. Singh, since you are coming from outside, you agree to a date?
After vacation, my lord, if it is not inconvenient to your lordship, and
Agree to a date,
Check
both
the
of you.
date. Check the date, please. 20 lot of matters are fixed.
16 July.
No, 16 July is holiday year. After
22nd.
22nd.
Can it be on 23rd, my lord, if it is convenient to my brother?
Yes, my lord. The 23rd, there will be a DV on the Thursday.
Then 24th?
22nd.
22nd, I have some.
22nd is Wednesday.
Wednesday. Monday, I'm all right, 27. Let us make it
Mr. G. Bamlan, Council.
27. You are free.
Petitioners.
27.
29.
29 again, the DB will be there. Right?
No.
Wednesday.
Next one. By referring to the preliminary objection raised
29.
by Mr. B.K. Singh, Lagan, standing also for the FCI regarding non-general or necessary of the Deputy Commissioner. Which place?
Daparijo.
Daparijo as one of the respondents. The United Senior Counsel for the petitioner has submitted that he has got.
Yeah, anyways, I have a judgment on this.
That he is ready to respond to this said issue. Next para. Both sides submit that similar matter can be tagged and heard together, being WPC
596 of 25.
596.
AP of 2025. So, accordingly, this matter stands adjourned today. List the matter along with WPC 596 AP of 2025
29, my lord. 29 July.
on
29.
1st July
29. 29th.
29th. Okay.
July.
29 July 2026.
Great friend.
29/7, man.
29/7.
Oh, 7. 27 July.
Obliged, man.
Item number 13 and 14.
Yeah, my lord, in item number 13, my lord, we need some more time to file affidavit.
My place, Lordship.
13.
Lordship, may I state the fact, Lordship. This is, Lordship, regarding the payment of compensation.
Compensation.
Petitioner's land has been acquired for construction of Trans-Arunachal Highway, Lordship. And while acquiring the land, the compensation was not computed in terms of LARA Act 2013 Act, Lordship. Accordingly, Lordship, writ petition was filed and it was disposed of by directing.
Give this state some time to file affidavit. How much time you need? Ms. Wangbo?
4 weeks, my lord.
Lordship, here,
4 weeks is a long time.
yes, Lord. Lordship, we have even the compensation was preferred after the judgment of single bench. It was preferred and computed under the LARA Act, but it was not disbursed only on the ground that, Lordship.
So whatever, but we'll have to
Lordship.
give them a time. Since the vacations are there,
Yes, my lord.
you file it in the reopening day of 20 July.
Yes, ma'am.
We'll take it up on 22nd.
Okay.
Without fail.
Yes, ma'am.
I never.
Both sides are represented. Steve Angul and the government advocate pays for some more time to file an affidavit in the matter. Next para, as the issue relates to non-release of the land acquisition compensation, the state respondents are directed to file the affidavit in opposition positively by 20/7/2026.
Yeah.
Next para, this is the matter on 22/7/2026. Next, we request the learned government advocate to send a downloaded copy of this order to the concerned respondent authorities. So the timely instructions are received by her. Next, list on so and so. You send a downloaded copy of the order.
Yes,
to the respondent.
My lord, date may be fixed, my lord.
22nd. 22nd.
Item 8.
Item number 13. And this analogous matter.
This is item.
Item number 14, I suppose.
13 of
The
14.
analogous matter, Your Worship.
Okay.
13 and
Here
14.
8 is written this way.
No, yeah.
Okay.
because-
13, I'm
Same order.
same order, my lord.
Okay. Same order.
Obliged.
Pass over item number 4.
Your Worship. My lord, maybe fixed on 29th of this month, my lord.
Okay, both sides are represented. On the prayer made by Mr. M. Kato on the DSGI, the matter stands adjourned today. Next matter is the case relates to challenge by the petitioner to the order of dismissal, the both sides will be ready for hearing on the next date of listing. Next para is agreed to by both sides on 29 of June 6, 2026.
Well, Deep Nupus.
Item number 15.
This
Yes.
Here, my lord, someone was taking adjournment this morning, my lord. Petitioner, my lord.
Hmm?
Petitioner was taking adjournment, my lord, this morning. This item, my lord, item
Gotcha.
15. Here, my lord, we have filed our affidavit. They have to file rejoinder.
Okay. Both sides are represented. The learned counsel of the petitioner submitted that the case is ready as regards service. Next para accordingly lists the matter for hearing. Asha, no. Accordingly, court is inclined to issue rule returnable forthwith without requiring any further steps to be taken. Next para is the matter for hearing on. When do you want?
So 15, sir. 15.
15 of?
No, no, sir. No.
15th of this month.
Item number 15.
Hmm?
Item number 15.
No, you want the matter for hearing when?
Oh, date.
For hearing. This is fixed for hearing. Fixing for
Oh,
hearing.
no. Isn't it?
Okay, give a date after 2 weeks.
2 weeks, no? 2 weeks. 22nd.
Yes, ma'am. To rejoinder file करने तो कर दो.
22/6/2026.
Yes, ma'am.
Item number 16.
This matter is on orders, my lord. Notice upon the response number 4 has already been served, my lord.
Yes.
File note, it is reflected in the file noting that 18/1/25.
We've seen that.
Yes, ma'am. So notice may be deemed served, my lord, upon the response number 4.
Okay, heard Mr. B. Pichal and counsel for the petitioner. And Mr. L. Parmel and standing counsel for the Agriculture Department appearing for respondent numbers
1, 2, and 3.
1, 2, and 3. Next, as per Office Note dated 18/1/2025, common notice is duly served on respondent number 4 through usual process. None appears on call for the said respondent. Yes, why we should not interfere with this transfer order?
The
allegation made against the MLA has not been denied.
Yes. Yes, my lord. In the evidence also, my lord, except my lord, in file was initiated on the basis of his you or not, my lord. But the relevant consideration, my lord, this petitioner, my lord, has already served 10 years in the place, my lord. That was the petitioner, my lord, has already served in the place for more than 10 years, my lord. That
10
was,
years.
my lord. That the consideration. That was, my lord.
Yes, if it is 10 years, then it is, you're already due for being released. It's 2024 matter. So you'll have to go now.
My lord, but there has to be some independent assessment by them, my lord. There is no assessment by them, my lord. Authority.
Not required. If it is 10 years, then the authorities will have, can transfer you.
Yes, my lord, not by mortgaging their power, my lord, to the
Oh,
MLA.
yes, they can.
My lord,
permit them. We'll permit,
I am with some judgment, my lord.
we'll permit that. If it is 10 years, then they will mortgage their conscience.
No, my lord. My lord, in this case, I was the respondent, my lord. Now I want to take benefit, my lord.
No, no, for 10 years, if you're there, 10 plus 2, 12 years now.
My lord.
No, it can't be.
I have one ailing mother, my lord. 74 years old. Now she's 76 years old.
Hmm?
I have one ailing mother, my lord, 76 years old.
That can't be helped. I have a severe back pain. I have to work, so I have to come here.
My lord.
There's no respite. I can't take I can't say that no, I'll not.
My lord, in this case, my lord, I was the respondent counsel, my lord. For the department, I was the respondent counsel, my lord. Now this honorable court, my lord.
It's okay. We
Pair 20, my lord.
But we can't.
Let them make their independent assessment, my lord.
Not required.
My lord, Para 20, my lord.
If it's 10 years, then the MLAs will have a right to ask for a transfer. 10 years is not permissible. You take note of this order.
But my lord, this is a revengeful posting, my lord. Revengeful posting, my lord. Revengeful posting, my lord. This was initiated by respondent number 4, my lord. Respondent number 4 is the MLA of our district, my lord.
It's okay.
Now I have not, my lord. My case is that, my lord, since I have not campaigned for his election, my lord, so I have been transferred.
But now 2 years have passed.
Yes, my lord.
Even from that, you got your relief for 2 years.
No, my lord, what I am saying that, yes, authorities can take their independent call, my lord.
Not when you have crossed 10 years.
In their affidavit, there is nothing, my lord. Nothing on record, my lord. They have taken this on record, my lord. On consideration, my lord. They have solely relied on the, my lord, this UO note of the respondent number 4, my lord.
But you have crossed 10 years threshold.
Yes.
You should have been transferred every 2 years.
That is another part, my lord. But they have to exercise their power independently, my lord.
We'll take note of your submission, but you're not inclined. But Mr. B. Pichar, I'm a counsel for the petitioner. And
in this judgment, I am relying on para 20, 21, 22, 23, 24, my lord. 20, 21, 22, 23, 24.
Standing counsel for the agriculture department, non-representative call for respondent number 4, although as per office note dated 18/1/2025, notice on respondent is duly served. Next paragraph.
Otherwise, my lord, can it be after a week, my lord? After a week, my lord. Since I am also not prepared, my lord. I was since the matter is on orders, my lord.
It's only one point. There's no requirement of being prepared. The petitioner is an agriculture development officer in the office of the Agriculture Office, Dapurijo. the petition is aggrieved by the transfer and posting order dated 28/10/2024, issued on 25/11/2024 by the Commissioner within bracket Agriculture, Government of Arunachal Pradesh, thereby transferring the petitioner from Office of the Agriculture Development Officer, Dapurijo, Upper Subansiri District to Hawaii HAWAI in Anjao District, for which the said transfer order has been assailed by filing this writ petition under Article 226 of the Constitution of India. Next paragraph. In brief, the case of the petitioner is that the respondent number 4, who is the MLA, 26 Dumporijo, DUMPORIJO, ST Assembly constituency, had requested the petitioner to support and campaign for his candidature as MLA for the State Assembly election, 2024. However, as the petitioner is a government employee, he had politely refused to participate in any election campaigning. It is projected that the respondent number 4 was hurt by the refusal of the petitioner to campaign in his election, and accordingly, by a UO note dated 8/7/2024, the respondent number 4 recommended transfer of the petitioner from ADO, Agriculture Development Officer, Dapurijo, Upper Subansiri District to Anjao District. Next, it is projected that pursuant to the said UO note dated 8/7/2024, the respondent authorities by the impugned transfer order number, to be page 32, number so and so, dated so and so, transfer 3 officers, including the petitioner, whose name appears at serial number 1 of the said list. The said transfer order. Next paragraph. In order to support this contention that the transfer was made through the UO note circulated by the respondent number 4, the petitioner has placed reliance on the RTI reply, which is annexed to the writ petition, is Annexure 6. RTI reply dated 5/12/2024. Right, Mr. Bichan?
Yes, sir.
Next, by the Land Council for the petitioner has submitted that it will be open to the state respondents to transfer the petitioner. So however, the assessment for for ordering transfer of the petition should be independent and not at the instance of the respondent of 4. So it is submitted that by transferring the petitioner at the behest of respondent of 4, the respondent authorities have mortgaged their conscience to the political bosses, and therefore the transfer was on extraneous consideration, as the respondent authorities had succumbed to the dictates of the respondent of 4, who was the sitting MLA. In support of his submissions, reliance is placed on the decision of this court in the case of Sri Gyati, Gyati, Pushang, Pushang versus State of Arunachal Pradesh and others, WPC 467/2023, decided on 22/11/2023. In the said case, transfer order at the behest of the Minister of the State was set aside. Next paragraph. The London Standing Council for the Agriculture Department has submitted that.
My lord, in addition, my lord, there are other victims also, my lord. In page 21, the MLA had the concerned respondent number 4 has you note against the teachers also, my lord, of our upper specialist. Page 21, my lord. This is the you note, yes. Page 22 is a type copy, my lord.
Okay.
This all teachers was also transferred, my lord, from the district, my lord, to other district, my lord.
Post topic is further submitted for him. From Mr. Pichai, it is further submitted that says that the petitioner is annexed to this writ petition list of 21 personnel who are regular teachers.
Yes, ma'am.
But they have also been transferred at the behest of the respondent of 4.
These are all political victims, my lord.
And it is submitted that those persons are also political victims of the
including me, my lord.
Next, the Learned Standing Council for the Agriculture Department has submitted that notwithstanding the allegations of being politically victimized, the petitioner has been at the has been working as Agriculture Development Officer at Daporijo, Upper Subansiri district for more than 10 years. And therefore, the UO note of the local MLA not vitiate the transfer. Just one submission, please record. I forgot of Mr. Picha. The legal counsel for the petition has also submitted that the petitioner has a 76-year-old ailing mother, and his son is presently studying in class 12.
Yes, ma'am. While filing this writ petition, yes, ma'am.
That time it was 10.
Yes, ma'am.
More than 10 years, my lord. 12, and therefore, if a transfer is made during the midstream, the education of the son of the petitioner would be adversely affected, and the petitioner would be prevented from taking care of his old ailing mother. Next pass.
One thing, my lord, I want to add, my lord. But while I was posted at Dapurijo is not the constituency of the 26 Dupurijo, my lord. Though it is within the Upper Subansiri district, my lord, but the separate constituency, my lord. I was posted at Dapurijo, my lord, not within the constituency of 26 Dupurijo, my lord. So I do not come under his constituency, my lord, now, while I am posted at Dapurijo, my lord.
Okay.
So some vested interest is there, my lord.
If you record that, then the sting of your submission goes away. Then
so my lord, he is outreaching his power, my lord.
No, not that. If he is not the MLA of the area where you are working, you can't campaign. So the sting of your argument is gone.
No, my lord.
You see, tomorrow, let us assume that an MLA from Kerala will call you and say that, Mr. Picha, please assist me in my campaigning here in Kerala.
Right.
You see, you have a good reputation as a good speaker. People call you from Kerala that come and make your speeches here, election. You say that, no, I'm a busy lawyer, I have to attend. Justice Surana is not leaving me. He'll be hearing a matter, so therefore I can't come. Now, if he recommends something, that would be beyond his jurisdiction. It takes away your string.
I was only on the protection by
what I'm saying is that I can record it, but it takes this sting away from your argument. Do you want me to record or you don't want me to record?
No, I was trying to protect myself from the judgment of Justice Kadju, my lord, which says MLA can recommend. Concerned MLA can recommend. I was not posted at that constituency, my lord, at that point of time.
It is not in dispute in this case that the petitioner has been serving as assistant. What is the name of the ADO? Means Agriculture Development Officer from Dapurijo. For nearly 11 years as on date. In the affidavit in opposition filed by respondent numbers 1, 2, and 3 on 24/11/2025, it has been stated that the petitioner has been at Dapurijo, Upper Subansiri district for more than 10 years. Taking note of the set stand of the respondent numbers 1, 2, and 3, the court is reminded of the decision of the Supreme Court of India in the case of State of UP versus Gobardhan Lal, GOBARDHAN, Gobardhan Lal, comma, within bracket 2004, bracket close, 11 SCC 420, comma, wherein it has been held that a government servant has no vested right to be posted at a place of his choice, nor can he insist that he must be posted at one place or the other. Full stop. Next, again, in the case of Shilpi Bose, SHILPI, Bose versus State of Bihar, within bracket 1991, bracket SUPP, then within bracket 2, bracket close, SCC 659, comma, the Supreme Court of India had again reiterated that the courts should not interfere with a transfer order which are made in public interest and for administrative reasons, unless the transfer orders are made in violation of any mandatory statutory rule or on the ground of mala fide. First, it was further observed that a government servant holding a transferable post has no vested right to remain posted at one place or the other, and he is liable to be transferred from one place to the other. First, it was further held that even if a transfer order is passed in violation of executive instructions or orders, the courts should not ordinarily interfere with the order next paragraph. In this case, the petitioner has alleged that that he had refused to campaign for the respondent number 4. In course of his submissions, he has also submitted that though the 26 Dumpuri DUMPO Assembly ST Assembly constituency falls within a part of Upper Subansiri district, but the respondent number 4 is not the elected MLA for Dapurijo, and accordingly it is submitted that the respondent number 4 had overreached his power and authority, and on refusal of the petitioner to assist him in the political campaigning, he was made a target of political vendetta, for which the respondent number 4 had moved the UO for his transfer along with several other teachers. Next paragraph. In the said context, the court would be reminded of the decision of the Supreme Court of India in the case of Mohammad Masood Ahmed, MD, Masood MASOOD, Ahmed AHMAD, with the is within bracket 2007, bracket close 8 SCC 150. Next one. Even assuming that the respondent of 4 did approach the petitioner to help him in the to campaign for him in the elections, which he refused. Nonetheless, it cannot be said that after having served at the same place of posting for more than 10 years, the EU note by the respondent of 4 would constitute mala fide for initiating the transfer of the petitioner from Dapurijo. Full stop. The state of Arunachal Pradesh has a transfer policy of nominal tenure posting of 2 years. And as the petitioners stayed in the same place of posting for 10 years, mere allegation of transfer being mala fide would not suffice for the court to stay the transfer. As it would prevent the state from enforcing its transfer policy. Next. The learned counsel for the petitioner placed reliance on paragraph 21 to 24, 21 to 24, 20 to 24 of the case of Sri Gyati Pushang within bracket Supra. In the said order, this court had placed reliance on the case of Tarlochan Dev Sharma, TARLOCHAN DEV Sharma, SHARMA versus State of Punjab and others, within bracket 2001, bracket 6 SCC 260, wherein it was observed by the Supreme Court of India that the officers, senior officers occupying key positions, such as secretaries, are not supposed to mortgage their own discretion from a coalition VOLITI1 and decision-making authority and be prepared to give way or being pushed back or pressed ahead by at the behest of the politicians for carrying out their commands having no sanctity in law. Full stop. A similar observation was also made by the Supreme Court of India in the case of Parbatpur Company Limited, PURTAB PORE, Parbatpur Company Limited versus King Commissioner of Bihar, within bracket 1969, bracket 1 SCC 308. Wherein it was observed that the authorities should not mortgage their conscience to the political bosses. Full stop. Next paragraph. Next paragraph. The facts of the case of Sri Gyati Pushang within bracket Supra is different from the facts of the present case in hand. Stop. In the case of Sri Gyati Pushang, the petitioner therein was transferred from one place to the other in the year 2021 by order dated 28/7/2021. Thereafter, by another transfer order dated 17/6/2022, he was transferred to a second place of posting and where the said petitioner had joined, and thereafter came the third order of posting of 22/9/2023, whereby he was sought to be transferred to the fourth place of posting. First of all, it is at the set fact situation that this court had made observations in the said case while interfering with the order of transfer. First off, in the present case in hand, the petitioner, having been posted as Agricultural Development Officer at Dapurijo for last more than 10 years, cannot have an invested right to continue at the same place of posting. First off, the transfer being an incidence of service, the petitioner has ample, the respondent authorities had ample power to transfer the petitioner from one place to the other in exigencies of service. First off, as the transfer was made after 10 years, the court would not scrutinize it merely because the same was initiated at the, what is the full form of UO? What does UO mean?
Unofficial order. Unofficial note.
Unofficial order. Okay. UO within bracket, unofficial order by the MLA concerned. First, it is not that the court is giving this approval to the transfer at the behest of the MLA. Mr. Power. In this case, the petitioner is found to have been in the same place of posting for more than 10 years. And therefore, the said UO note of the respondent before is not found to vitiate the transfer of the petitioner. Next paragraph. Accordingly, the case of Sri Gyati Pushank, cited by the Learned Counsel of the petitioner, does not have the petitioner under the unique facts of this case. Next paragraph. In this case, the petitioner has projected that he has a 76-year-old ailing mother. What is the distance between the two places where you have been transferred?
My lord,
Dapurijo to
Anini, my lord.
how much distance it is there?
It is my lord, something 500 something, my lord. More than 500, my lord. Probably, my lord.
Under the circumstances, the court is inclined to
It is not a one-day journey, my lord.
it's okay. Is inclined to direct the petitioner to join the place of posting. So how it would be open to the petitioner to make a representation before the head of the department for reconsidering the transfer of the petitioner to a place. So any place then to the nearby, which should be nearby. Not nearby, which say that which can be traversed by 3 or about 3 to 4 hours of journey. Not 3 to 4. You can. How will I say it? Up to 4 hours of within 4 hours of journey time. First off, we request the on such a representation being made, we request the agriculture department is headed by commissioner.
My lord. No, secretary, my lord.
Secretary.
So now secretary, my lord.
The government of Arunachal Pradesh, agriculture department shall consider the same and pass appropriate orders without being influenced by this order. Next, by the authorities shall give a reasonable time to the petitioner to join his place, the transfer place of posting. Next, the petition stands closed with on terms and indicated above.
Pass over matter item number 2 and 3.
The short question is, the applicant was appointed as MTS, my lord, in 2018, my lord. And thereafter, in 2021, he was regularized, my lord. But very fairly, my lord, without following the due process of law, the requirement under Article 16, my lord. Then thereafter, my lord, what had happened was the NPS number was also allocated to her, and she was drawing the salary and deductions were being made against that account. One fine day, my lord, what had happened is by impugn order dated 6/11/2023.
Not filed affidavit here?
My lord, I have filed, my lord.
Is it?
Yes, my lord.
Another boy.
27. Okay.
Then, my lord, the impugn termination order was issued without affording an opportunity of being heard, my lord. Now, secondly, my lord, what had happened? The termination order, my lord, was done on the basis of the recommendation of a committee, my lord. Now, my lord, these aspects, my lord, my lord's brother, Justice Mehdi, has decided this matter already. And interfering with the impugned termination order, reinstating the services of the petitioner in one matter, the same department, my lord. And then thereafter, my lord, the state was given liberty to initiate fresh course of action. Whereas here, yes, my lord, kindly.
Yes, Mr. Tagum, same will follow here.
My lord.
Same principle will be followed here.
Lord,
Yes,
this
my lord, same born out of the same FIR which they have lost. 315. You see?
No, my lord, this is altogether.
You see from here. See from here. Give it.
That's just one.
See from my left. Your education department only. Where Jamo was there, my lord.
That I don't feel that, my lord, it would be relevant for this purpose. But this is altogether the genesis, how this the thing come up, my lord. That's altogether there's a different story, my lord. So this on what background, my lord, this was passed, my lord. That may not be applicable in the present case. I believe, my lord. Because in the present case, my lord, the large scale job scam,
Same
legal
thing, connected
appointment
with the
done, my
same
lord.
case.
Okay. Yes.
So, my lord, kindly come to page 17. What my learned brother has made a submission that this order will not be applicable. I will demonstrate, my lord. There is the same Standing Council Education Department on the same facts, my lord. Well, page 17 is my appointment, my lord. There is my class 10 pass certificate, my lord. Then page 18, my lord, I put an application, my lord. MTS, appointment as MTS, my lord. It is by dated, my lord, 11/6/2018. Then, my lord, page 19. On 22/6/2018, I was appointed, my lord. Then I submitted the joining report after 4 months, my lord. 22/10/2019, I joined, my lord. Then, my lord, kindly come to page 21.
Tagum.
My lord.
You please come to page 21.
Page 21, my lord.
Yes.
My lord.
if she has been regularized, then you'll have to, undertake the due process of law and then terminate.
Correct.
They have good ground that it was a job scam and other things, but when a service has been regularized after the probation period, she's
My lord, in regarding this page number 21, my lord, in my respectful submission, we have taken ground, my lord. This has never been originated from department. Even the impugn order, that appointment order, this has not been issued by the department. This is fake, my lord. In collusion with the earlier, it was
you'll have to,
my lord, that is why, my lord.
it is fake.
My lord.
Then you'll have to have this put it to notice.
My lord.
By an inquiry made somewhere else.
My lord.
You terminate that service.
My lord, that part, my lord, if it is illegal, my lord, because the investigations are going on, my lord, large scale theft. That's on the record, my lord, we have taken on the affidavit that.
No, investigation is just a police investigation or some CBI or CID.
My lord,
correct.
SI, yes, madam. A special investigation.
Has any charge sheet been submitted against the petitioner?
My lord.
Has any charge sheet been submitted there?
My lord, that part is around, my lord, in the, various 12 district, 12 or 13 district, my lord. The investigation going on, my lord. So, my lord, in my respectful submission, in such nature of the cases, my lord, the formal disciplinary inquiry even is not required. So far, even in the protection under article.
No, then you invoke what you call this, the protection of 311(2) and then say that this won't be applied.
But this won't be applied in such cases, my lord.
That is not what you did.
My lord.
You did not dispense with that inquiry.
My lord.
You must pass a specific order under 311(2).
My lord.
Saying that it is not required and therefore you exercise that power. You come to your the order. This is your termination order.
My lord.
Because here you see page 3, you say two things. Number one, you say that the committee found that such appointment orders have never been issued. If it has never been issued, in the next paragraph you say they stand cancelled. So if it is not issued, then the issue of cancellation will never come.
My lord, this is I'll my lord, just clarify this point, my lord. They have the person who had issued, my lord, he's got retired, my lord. Director Elementary Education. He's the kingpin in entire episode, my lord. He was arrested, my lord. Now, in collusion with these, the officer, some of the officer and the beneficiary, they locate the post where vacancies there, my lord. Against that, they have issued a fake order, my lord, without approval of the government and authority, without doing any selection process, my lord. That was, my later on, it was detected. That was in fact not originated from the department. That's why, my lord, the pay were being drawn, my lord, in the various places. And wherever the pay is being drawn from state exchequer, that was detected.
You better produce that inquiry file. How this inquiry was made. A mere statement in the termination order at page 23, that will not help you.
My lord, last occasion also I requested through the court, to the London Standing Council, to bring that inquiry committee report in the form of affidavit. So the
affidavit may not be required. If it is an ongoing police investigation, then we may dispense with premature disclosure. If it is a fake scam, fake appointment order scam. But you have to produce before us.
My lord, because in this entire, my lord, the subject matter is now under the investigating authority.
You will find out and you will find one of my orders where the entire APSC scam was interfered with.
Correct, my lord.
Although the single judge upheld the termination,
my lord,
but sitting in the division bench, we took a different view. That will operate against you. We are doing two things. Number one, there is no dispensation of inquiry under 311(2). Second is that you lay an imputation of the fact that this was not there. In the termination order, you pen down adverse remark.
My lord.
For that adverse remark, he has to be heard.
My lord, the show cause notice was issued, my lord, and there, even if, my lord, it is.
Your termination order is clearly speaks that it's a fake order.
But it's fake order. But that's why, my lord, my
If
lord,
it's
in
a
that
fake
case,
order, then there's a stigma attached.
my lord,
Stigmatic.
in that case, my lord, the doctrine of empty formality, my lord, even the principle of natural justice, my
That
lord.
will come only when you had dispensed with under 311 and then proceeded. Then empty formality. It can't be said that you don't exercise that power and then say it is a empty formality.
My lord.
Now what happens if I'm just giving a suggestion? I'm good in giving horrible suggestions. You see, what happens if somebody comes and now says that the authorities who have cancelled it, they asked for this favor and that favor and we did not give, and therefore he's made that submissions.
My lord, my lord, see, when it is authority is brought to the notice, my
When it is subject matter of inquiry,
lord.
that means there is no finality attached to it.
My lord, so far fact who has committed and who has not, that is part of it. But so far issuance of the appointment is concerned, my lord, it is we have.
But please tell me.
Second view, my lord.
But please tell me, has the inquiry culminated in a form of a report?
My lord.
You say that it is still going on.
My lord.
So,
but this is incurred part of the criminal point of view, my lord. The forgery and fact that part. But so far our stand, the department stand is that, my lord, the appointment order has not been originated from the department, my lord.
Doesn't make sense.
My lord.
You see, Mr. Tagum, you are taking two stands. Number one, the inquiry for civil liability is over.
My lord.
But the inquiry is going on for the purpose of settling the criminal liability. Criminal liability, the department doesn't take care of it.
My lord.
That will be the police or the investigating agency. So therefore, your inquiry can only be limited to the fact that there was a fact-finding inquiry and you are given a report. And this report must have been submitted to someone. That lends finality to that inquiry. Unless you can show otherwise. Can there be a criminal investigation by the department? No. Settling of criminal liability, you can't say, you can't give a recommendation that I, the Commissioner Secretary of so-and-so, hereby charge him for criminal conspiracy of so-and-so. That you can't do. You will only recommend that this man has done it, and therefore you recommend that action should be taken against him. What will your authority do? If you are the authority, you are the Commissioner Secretary, what order will you will pass when a scam like this comes to your notice?
My lord, the whosoever, my lord.
You will always make an inquiry, give a finding of fact, and then say that the report is submitted to the government. So that lends credibility to and the finality to your report. You can't give an interim report and then say we terminate, therefore the inquiry is still continuing. Therefore, the termination is based on an interim order, interim finding.
My lord, it is not even interim finding. My lord, the fact, what I'm submitting, my lord, there's no relevant records, but that has not been whatever they are claiming as appointment. But that has not been originated from the department, my lord. Only we come to know that they are the certain against the vacancy, my lord, when officially appointment has not been done, but the pay is being drawn in particular area, and that is why, my lord, this has come to the light of the authority, my lord. My lord, that is why, my lord, when we know that this has not been issued from the department.
So in the state of Arunachal Pradesh, what happens when a person is appointed to a post by the government? Because you see, there are many departments who deal with the first salary departmentally. And then for the second salary, it goes to the treasury and it starts, the disbursement starts from the treasury only after the first disbursement is made by the departments. That is followed by many places, including Assam. So in this case, what happens is that there was a fake order. Let us say there is a fake order of MTS. Who paid the first salary? Or is it your case in your affidavit? Because it is not. In your affidavit, you have not said that the fake orders were passed and the first salary was never drawn by the MTS as a regular employee.
That is why, since it was without authority, without the approval of the
Who
authority.
released the salary?
My lord.
Did she get or the petitioner did not get a salary?
My lord, that's why, my lord. The salary were being drawn, my lord. And then
being drawn.
It's come to know, my lord. That's why.
Therefore, you see, everything would be necessary that when it was drawn, when it was deducted, you see, Treasury doesn't start paying salary just like that without an order being communicated to them. There will always be a cross check by the Treasury. You ask them, the first bill will come to them.
My lord.
It will be authenticated, and then only the first salary is being disbursed.
My lord, salary part is concerned, my lord, that is, there's a salary head, my lord. And again, under the salary head, the particular post is sanctioned, my lord. Against the sanction post, this gentleman, my lord, who issued the appointment order, my lord, in the large scale, my lord, he knows, my lord, in collision with those beneficiary, and he knows the where that post is lying vacant. Against that post, without approval, he issued the order without approval authority, my lord. And that was going on, my lord. And when the authority come to the notice of this fact, my lord, they started doing, taking action, my
That
lord.
is your word. Where is the records to substantiate? You have not annexed any of those things.
My lord.
Either you produce the records or file additional documents to that effect, whatever way. But today, as it stands, this has to be quashed.
My lord, my respectful submission, my lord, my understanding, my lord, limited understanding, my lord. My lord, if when it is known to the authority, that is, the order is non-existence, my lord, it's illegal, my lord, then authority is bound to take action, my lord. And action, my lord, this all formalities, departmental proceeding, and this inquiry is required where the person has been validly appointed. But in the present case, my lord, they have not been validly appointed. And against the main kingpin of the case, my lord, he has been arrested and investigations are going on around, my lord. Large scale, my lord, as per affidavit of 295, such large scale appointment was done, and that has been terminated, my lord. All of them. It's not the case the petitioner alone, my lord.
We are not concerned with others. Only one has challenged it. Before us, we have only one case. You have to produce the documents showing that. If you're not producing the records, then we ask the order as we deem appropriate. You are heavily relying on this report of the inquiry in your termination order. You see what happens if the appointment order is fake.
My lord.
He or she, the petitioner is lady, yes, she was appointed as MTS on probation basis. Correct.
My lord.
Now the appointment order is bad. Then what do? You revoke only the probation, the what you call the this page 21 order, by which there was a regularization.
My lord, see page 19, my lord. That's the appointment order, my lord. 18. Now this has been issued by one Tapigao, my lord, Director Elementary Education. Now this thereafter, my lord, at page 21, that's the same person, my lord, and he knows, my lord. It's not with the approval of the government, my lord.
Appointment of MTS was also done without
Any selection process, my lord. Without any selection process, my lord.
My lord, the only
Yes,
assistance
not
I
on-
can
not
render
on
at
case.
this moment is MTS, my lord, the appointing authority is the director,
My lord, that,
director of the department.
No,
in
affidavit,
all
don't say
the
so.
jobs.
my lord,
He did not say
on
any-
affidavit, my lord, we have annexed even the recruitment rule, my lord. Recruitment, my lord will see it.
No, but you must give a statement that it is, the appointment was illegal. Even the appointment as MTS. You come to paragraph 3.
23. Now there.
Paragraph 3, my lord.
This is what you say.
Yes, my lord. Without conducting any selection process in violation, my lord. Para 3, 3.1, my lord. And 3.2, my lord.
No, sir, this won't do. There is no document annexed to show anything which you are saying. It's not supported by any record. And the affidavit, paragraph 11, page 37.
My lord,
You only say it's true to my knowledge. This means is not based on record. Only paragraph 6.1 is based on record. And 6.1 is only the method of recruitment. It's not the, you are not assailing the, nothing on record has been shown that this is not there. Your affidavit is very clear. Everything is true to your knowledge.
this, it is, my lord, even they, it is admitted fact they have done, the appointment has been done without any selection in violation of the recruitment
Who
rule
has
and not,
admitted that?
my lord.
Who has admitted that? Petitioner has not admitted that.
My lord, the petitioner part, they have never, even in the pleading, there's no even single statement saying that
I've been appointed.
even appointed, but we say that
You
this is
say
the
that-
illegal appointment, my lord.
You say it is illegal appointment. Then
My lord.
how do you take that decision and then put it here?
My lord,
You see, it's personal knowledge of this, of the deponent.
my lord.
There must be something on record. The department would have undertaken some process and then your knowledge would be derived from the materials which are available on record. You don't see anything in this affidavit. He's serving as a deputy secretary. You see, there you must first show your hierarchy.
My lord.
That a department, the director who's giving an appointment, he has to take the permission from the from the secretary of that department.
My lord.
If he is the appointing authority, then also he will route the order of appointment to the state.
My lord, that is, and that also, that has to be done in consonance with the recruitment rule, my lord.
Those things you don't say that it was never done. This was never routed. This is the policy of the government to appoint. And this information of appointment were never provided to these authorities. At least the secretary will come and say that, yes, in my file, there is no document shown for that appointment. Nothing which is expected of an affidavit is here.
My lord, in that case, my lord, I may be granted, my lord, sometime I'll file the detailed affidavit, my lord. Additional affidavit on this point. Because, my lord, it has a large ramification to the society, my lord. The old, around 300, my lord, illegal large-scale
No, not
appointment.
300, let it be 3,000, but you'll have to terminate in accordance with law. You see, come to page 19.
19.
My lord.
This is the appointment order.
Yes, my lord.
He has given this orders to all these authorities, and you don't say that this the appointment orders were issued to
It's only-
1 to 7, sorry, 1 to 6. But the requirement of law is that under the recruitment rules, it will be the information must go to to a particular section or department, officer in the department, secretary.
My lord,
If he's the appointing authority and the disciplining authority.
my lord, when it is, my lord, this order itself is, my lord, it has not been originated from the department, my lord. That's only mere it mentioning, my lord. That would not rectify the illegalities, my lord.
We will show you that. You see this statement here is in the writ petition, it is paragraph 6. Correct. Reply to paragraph 6 is in your paragraph 6 of your affidavit. Please read what does it say. With regard to government made so and so, your answer expects to retain the appointment of the petitioner posing illegal violation of norms. No selection process was conducted. It mentioned the post of MTS governed by regulated by several set of rules in the case petitioner has been upon not done the permissible mode of recruitment in regard to so and so. You don't even say here about that illegality committed.
Under recruitment rule, my lord, 75% is for direct recruitment, my lord. That is through competitive written examination, my lord.
No, here what has happened, this is appointed against somebody.
My lord.
Page 19. This appointment is made against late Tapang Talo.
My lord, that only this director, he knows, my lord, there's a vacancy, my lord. Against that, without approval, my lord, without any following process, my lord, is appointed, my lord.
But first of all, you have not shown us who's the approval authority. Those statements made in an affidavit. Because you admit that he is the appointing authority. If I am the appointing authority, would I have to take permission from somebody to appoint him? That is the only question we are asking you.
But without approval of the government, my lord. If suppose.
No, he becomes the government, he is the appointing authority.
My lord.
You see, you'll have to show us the entire scenario that this is in the state of Arunachal Pradesh, this is how recruitment are done. This is the approving authority. Nothing has been shown here.
My lord, now, my lord, this MTS, my lord, this selection or recruitment process done by the staff selection board, my lord, Arunachal Pradesh staff selection board, in concern with the recruitment rule, my lord. But in this present case, my lord, that has not been done, my lord.
Where is that rule? You have not even placed that. You don't even say in your affidavit to that point.
My lord, we will bring it on record, my lord. This all fact, my lord.
Only after we ask you. We give you a fair opportunity, but you are insisting for a hearing.
My lord, even the recruitment or particular recruitment rule, we have annexed, my lord. That for selection, that there's a staff selection board, my lord.
Which volume we will get it? Which book will get it?
My lord,
you have not annexed here.
My lord, it is not in the AP code, my lord. The staff selection board, my lord. Will my lord bring it on the affidavit, my lord? It's governed by the Staff Selection Board Act, my lord. And relevant recruitment rules, page 39, my lord. 75% of has to be, of the total sanctions post has to be through recruitment process as per this recruitment rule. Written examination. You read this. Who is the appointing authority of MPS?
Mr. Thakur, we can't approve of what we're trying to do. What you're trying to do can be approved. Come to page 23. If your recruitment rule was not followed, then you'll have to send this Commissioner Secretary Education to School for Education. That is not even the ground for termination, that the recruitment was done in at a violation of the 2011 rules. That is not a part of this termination order. You don't go to the genesis of the termination order, saying it to be illegal.
Well, it says the document, the appointment order is a forged, my lord, fake, my lord, order.
Forged why?
Without following, without
That is not forgery.
My lord.
That is not forgery. That will be an excess of the mandate of the officer. If an order is coming out under my signature, then it is not a forged document.
My lord,
It may be an illegal document.
the person who has issued order, my lord, he's accused, my lord.
But
Himself
not
is
for
accused.
forgery.
My lord,
See, if I give appointment to A,
my lord, I'm saying fake because in the order, appointment order itself, it says that this appointment has been done in pursuant to the government approval, whereas it is not a fact, my lord.
you are improving it. That
No, my lord, it's there in order itself, my lord, the appointment order itself, my lord. It's already there, my lord. In pursuance of
You
page
see-
19, my lord.
You see, please be, I'm making it very clear. Once you make a statement with regard to an order, that order should be, it should reflect from the order itself. Order which has been passed cannot be explained by way of an affidavit. It is well settled law. We did not refer even to that, what you call MS Gill.
My lord, that is why, my lord, although the order
say
reflects,
anything.
this is
You just
pursuance of
terminate.
government order.
Whatever you are arguing is not covered by whatever is there in this termination order. It's an improvement by the learned counsel.
My lord,
You are explaining us and going, therefore we are going contrary to MS Gill, what you have learned. Your first submission is that the appointment order was illegal.
Yes, my lord.
That doesn't come from this termination order. You say that the recruitment rules was not followed. That doesn't speak out from the termination order.
My lord, there in the order, my lord, page 23, my lord, the termination order, my lord. It says, whereas it's been brought to the notice of the competent authority that the following primary teacher, PRT and multitasking staff have been appointed, recruited by the producing force and fabricated
Fabricated
appointment
appointment
order without maintaining
No, it
departmental
can't be
oral
fabricated
formality.
or forged. See,
And
the authority, this appointing authority, he has not given a statement that he is for his.
I mean, he himself is accused, my lord. He himself and the
Try
entire
to understand.
this
You have
entire
followed the
this,
question.
my lord.
Who will say it is forged?
My lord, department is saying, my lord, because this is
No,
not in the originated,
department.
it
If
is not
my-
original
if
official
supposing
record.
Today, order has come out in the come out before any authority. Using this, what you call my signature, then it would be placed, if that is in the comes to the domain of the court, then this will be placed before me. And I will say this, I have not passed the order because today this matter was not listed. I have not passed this order. And therefore my signature is forged. Therefore, it will be the authority who has put the signature will first say that it is a forged signature. Who will say it is forgery? Forgery was never, you have not produced anything before us to say that the author of this letter has agreed to that this signature was forged. If it is forged, then you'll have to ask the accused that how do you get this order?
Well, that is why, my lord, we said, my lord, this appointment order has not been originated from the official record, my lord.
Malab, in fact, next day, Malab, in fact, the very director under whose signature these orders were, he also denies that I have not given this appointment.
You have not even said that in this order.
No, that is not in this order. Even when the inquiry was commenced, there were
as a
yes, my lord.
you see, you forget that you are the additional AG and then you are there. As a council, what will you do? Will you accept explanation of an order contrary to what is there in the text of the order?
My lord, what it
Stories,
says,
anybody can.
what it says, my lord, this order, if I'm correct, my lord, this it first says that their orders, appointment orders, are forged and fabricated because the very origin of these orders are not known. Even the director, who is under whose signature it was, he also has said that I have not given, and there is no record in the department that these appointment orders were originated from the department. These were given to the districts. Now, my lord, apart from this, what actually is the subject matter will be, my lord, with regard to my lord's judgment in this, the APCS, Assam APCS, in that case, my lord, there was at least a selection process, and the authenticity, the veracity of that selection process was doubted. In that background, my lord has given that judgment that even in they have even in such cases they have to be given a chance to address, to show cause for those who have been regularized. Now, in this case, here there is no selection process at all. There was not even a selection process. No selection process, pick and choose, and appointments they were given under whose. That also.
No, you see, Mr.
First, they have to.
It's very difficult. Once you make a statement, Mr. Tagum clearly made a submission that the director knows where there are vacancies and therefore he appointed placed people there. That is his first submission. Now, with that submission, your submission that the director had resiled and said that he did not issue that order.
Yes.
Is it compatible?
There are so many appointments. Even the director, he didn't. He denies that it is under his signature.
But that is not the submission made by Mr. Tagore.
No, there because the vacancies
No. You
were
can't
known.
stand. Either you produce your records, or you leave it to us to pass the order. You can't explain the text of the order with the explanation which.
Basic, my lord. But what basic is that? Apart from forget about the forgery or whatsoever, first the writ petitioners will have to first establish that they were appointed by following a due process of law.
No, due process is you are denying. The petitioner does not come and say that he is denying the due process of law. He said that he has been appointed.
Yes. Whether the question he is silent because he knows he has not
wrong. If you make that submission before this bench, then you are absolutely wrong. You have the Evidence Act with you. You see this.
Yes, my lord.
See illustration E of section 114.
It is 119, Malad, in the BSA.
I won't remember the new ones. I forget.
BSA 119.
114 illustration E. All judicial and official acts are presumed to be duly performed.
Yes.
So it is he has produced the order and he has shifted the burden on you. You will have to show it is not duly performed. The burden is on you.
My lord,
First, onus he is discharged.
yes, yes, my lord, in the affidavit, at least that in reply to para 6, the authorities have said that without any selection process, they have been appointed. Now, when there is a statement making that there was no selection process in appointing the writ
But
petitioner.
that is not your order, the termination order at page 23 doesn't say so.
In the affidavit, at least they are saying.
Affidavit can't explain. MS Gill is very, very clear.
MS Gill, I'm not, prior to even what is there in this termination order is false and fabricated. Even if we assume that it was a genuine one.
No, Mr. Ratan, please take us time. Either you argue the matter on merit or you produce the records. Of
Will-
the two what you're trying to
let
do.
my friend produce the record, my lord. Of
Then do
course.
it. Then there's no point of arguing.
Yes, my lord.
By when you are producing it?
Please. My lord.
My lord, it requires my detailed affidavit, my lord, detailed
No
records.
further
required.
affidavit, my lord. It's not
My lord.
permissible. You produce the
At
record.
least the record,
Thereafter, it
how
is
this
listed.
order has originated, because after what exercise this order was issued, the impugn order saying that it was false, fabricated, how this order came to be issued, at least that there has to be an exercise. There was an exercise done. That record, there might have been, there should have been an inquiry. After the inquiry findings, then this order came to be passed. It cannot be passed in the air, madam. That records at least should be produced, madam. At least my lord will see what was
You
the
are
origin.
filing an affidavit first,
My lord,
but produce the records also.
my lord.
How much time you need for the affidavit?
My lord, at least 2 weeks may be granted, my lord, 2 weeks time, my lord.
Calendar, take a date.
My lord. My lord, 24, my lord.
You will be filing the affidavit by 24th.
My lord, 24, my lord.
Okay. We take up this matter on 25th then.
My lord. My lord.
Mr. Tara, any difficulty? So then it has to go to July. Last week would be most probably, in all probability, motion days.
Yes, sir.
Sir, June 30.
30, my lord, we can. 30 June.
30 June will be very difficult for hearing because it will become a motion day.
Yes. Tuesday, no?
But then it goes to July. After we can fix it as early as possible is on 21st of
1st July, my lord. 1st July.
No, 1st of July is again the before vacation. It will not be heard. Then it goes to 21st. That is the next possible date for hearing. So,
On that day, there is a division bench on 21st.
okay, 21st. So 22nd then. You file your affidavit by 24th.
My lord.
Reply, if any, will by the petitioner will be filed in between.
My lord.
And 24th will be the date fixed for hearing.
My lord.
May it please, Your Lordship. Your Lordship, I am for the petitioner item number 3.
Item number 3.
Connected.
Item number 2, past separate orders. Huh? Item number 2, her visit T.T. Dara and senior counsel, assisted by Mr. G. Bam, the counsel for the petitioners. Next para. Mr. N. Ratan, the additional AG, along with Mr. T. Dagum, the standing counsel for the agriculture department. Sorry, education department. Please for leave to file an affidavit to bring on record the facts leading to the issuance of termination order dated 16/11/2023. And also to produce the records in support of the same.
My lord.
Stop. Prayer is allowed. The matter stands adjourned today. Next para. The affidavit by the state respondent shall be filed within 24/6/2026. Reply, if any, by the petitioner shall be filed within a week thereafter. List. Next para is agreed to by both sides. List on 22/7/2026. And the item number 3.
Yes.
Your name?
Geeta Tak.
Cordial.
I'll tell you because though we are granting time, allowing you to file an affidavit, but still I would be it would be a difficult proposition for you. The reason is very simple. You see, if you have arrived at a finding that this was forgery, then your inquiry cannot go on. Your inquiry going on also reveals that whatever thought process you are having is still doubtful. Otherwise, if the authorities arrive at a decision that the appointment orders were forged, then what would be your next recourse? Will you keep that inquiry pending?
My lord, inquiry was conducted by the department. Now, after finding, it has been sent for investigation.
So there is no, according to you, there is no report.
Preliminary inquiry, inquiry was that, yes, there was some
Look at
which
your,
is done.
your leisure time, look at this affidavit.
Yes, ma'am.
Does it say the inquiry was culminated? No.
My lord, in that order, my lord, this inquiry report, my lord, even up till times, I made a submission before this honorable court to direct the Standing Council Education Department to furnish the inquiry report. They are not
that's
furnishing.
difficult. That proposition is difficult. Once there is a forgery alleged, a criminal investigation is pending, then to prematurely call it, I have some reservations.
Fine, my lord. That
I have my reservations. Therefore, we are saying your proposition is again issue which is debatable. The inquiry, if it is culminated, then your order would have said that the inquiry culminated gives this report. That doesn't say.
No, inquiry was never culminated, my lord. Nor there was a DE proper. The due process was followed to terminate as blood.
It's very difficult to accept what you are saying.
Yes.
This is okay. This would be Mr. Tara.
My lord.
19.
Yeah, 19.
Mr. Kato is not there.
My lord,
No. Mr. Kato, in the earlier orders, we passed directions for the postal authorities. The post office for our court, where do we send it for registered post?
Lordship?
Steps which are taken from this court
Yes, Lordship.
goes through which post office?
Naharlagan.
Nahalagan.
Naharlagan.
Naharlagan this sector. Naharlagan this. Very much.
In this case, we are CGC is not there. In this case, we are directing the postmaster of the Naharlagan post office to be present, to file an affidavit and to tell us. If he does not file an affidavit, then his personal appearance would be required. Here again, it's very thing serious. Pursuant to order, the postal track report of respondent number 6 and 8 has been generated several times, but the same was not updated. As on date, the status shows consignment detail not found. These are at flag A, B, and C, A and B. Since more than 3 months has passed, therefore there's total failure of the postal department here.
Madam, she can inform her senior, madam. She is Mr. Kato.
No, that is nothing to do with her. It's the
Yes,
failure of the
can
postal
inform,
department.
The same observation of this one.
It will come in the form of order.
No, that's why we are passing. In the
Yes,
morning,
yes,
we
but
pass on
that's
order only because of that. Because we can't lead to failure of court orders because of postal department. Your name?
Why the Lordship?
Why?
Gao.
Heard Ms. Y. Gaur, learned counsel for the petitioner. And Mr. T. Tagum, learned standing counsel for the Education Department, appearing for respondent numbers
1,
1, 2, 4. Next, as per office note dated 6/6/2026, answer of notice in respect of respondent number 5 is returned back with postal remark, person not found, RTS. RTS is the short form of return to sender. Next, as per the said office note, in respect of the postal track report, the following observation is made. This one, office note. Here, green flag of 13/3/2020. There's a pencil mark. Only quote this. Next para. The learned counsel for the petitioner seeks liberty to serve notice on the respondent numbers 5 to 7 to 5 to 8. By Dusty mode. So prayer is allowed. The petitioner shall serve notice on respondent numbers 5 to 8 by Dusty by routing the process through the registry of the court, and upon service, an affidavit of service shall be filed prior to the next date of listing. Next para.
And
in view of the hearing before quoted office note, the court is inclined to direct the is inclined to take to make an to take a view that there is a systematic failure of the postal department in the state of Arunachal Pradesh, because the postal track consignment reports have not been updated, leading to failure of service of notice of issued by the court. Accordingly, the postmaster of Naharlagun Post Office is directed to show cause as to why the postal track reports in respect of respondent numbers 6 and 8 were not updated or returned to the court with its regular official with the postal remarks. Full stop. the registry shall, no, the postmaster of the Nahalagan post office shall take note that if affidavit is not filed to show as to why the postal track reports were not updated, despite the authorities being aware that those were communication issued by the court. The court may pass orders to for his personal appearance with the relevant records. Next para. You also take note of the fact that the steps issued by the court through postal service are not returned within due time, and several orders are being passed every day with regard to the lack of proper service and return of the postal articles with appropriate remarks. Which has necessitated this court to pass the order, this order against in respect of the postmaster of the Nahalagan post office. Next, the registry shall serve a copy of this order together with the consignment report at flag A and flag B to the postmaster, Nahalagan post office, to special messenger. And the same shall be received by the said authority with an endorsement in the receipt copy of the letter, which shall be kept as a part of record. Next para, the order be brought to the notice of the registrar of the Itanagar Permanent Bench to take effective steps. Next para, the notice issued on respond numbers 5 to 8 is made returnable by Dusty mode is made returnable on so and so. Give date after 5 weeks. Returnable on so and so. List on so and so.
22nd July.
And Lordship, if Lordship may allow us to take those unserved notice.
Yes, definitely. Just before that you say, whereas the notice is made returnable on so and so, the last line, there you had the court permits the counsel for the petitioner to collect the unserved postal postal articles and to resend the same.
Okay,
that is good thinking. We appreciate that. In fact,
Item number 10.
Please, Your Lordship.
And on the last occasion, this honorable court directed us to file the status report, action taken report in the form of an affidavit. We have filed 2 additional affidavits. One by the
but what is your stand? You see,
Yes,
they must have an access to the
yes,
to
my
the
lord,
industry and
we have
then
explained
outside
that. In fact, we are doing our best to comply with this honorable court's order, as well as to give protection to the petitioner factory also.
Oh, if the state wants, they can do it in
My lord, yes,
in an
yes,
hour.
of course.
If you
My lord,
don't
we
have
can.
the intention, then it will take months and years.
My lord, we have done a lot. In fact, the petitioner also will not deny it. My lord, will kindly come to page 489. 489. This is the action taken report by the.
Just a moment. Yes, which page you want us to see?
Page 489.
489.
489, this is the action taken report filed by the SP of East Siang District pursuant to this Honorable Court's direction, my lord. 489. My lord, first
You
of all,
you have a mobile with you, no?
yes, my
You
lord.
have a mobile. You please find out there's a case of James Merdit, James Meredith.
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 James Merdit.
James Merdit. You got it?
Merdit.
You are reminding us of something which you read in law college. JAMES, James.
James Merdit.
MEREDITH.
In my colleagues
It's not
Google,
working.
Google, it comes out James Mudot, not Merdit.
James Merdit or university, you can add the University of Mississippi.
James Merdit.
James Meredith, University of Mississippi. Okay, even if you don't get it, I'll tell you what happened there.
Yes, ma'am.
This was one of the first cases when there was apartheid practiced in US. This James Meredith faced violent opposition because she took admission in a college which had only white-colored persons, and that is in the year 1962. What the US government, through the federal government, did was that US Marshals were sent there. That's been the armed forces of US. They were sent along with this student to be admitted into that university. So if any protests, they had the authority to shoot at sight.
Yes, my lord.
This I am recollecting.
Exactly.
This is something
Yes, exactly
was in
applicable
college.
in this present case also. My lord, that's why.
See, if the government wants, there's nothing you can't do.
Yes, my lord. Yes, that is there.
But if you want reports that
my-
can
my
be
lord.
endlessly brought in,
That's why our action taken report and what actions we are here. We are
so
also
that is 7th of May. Now we are in 8th of June.
no prior to that. What was done that also is there. Prior to
We don't require past.
Yes.
What we require is the
and
future.
what has been done because as a government, my lord.
I'll tell you, I am suffering from some cough and cold. I go to a doctor. He tells me that no, the medicine I will give you, but let us study what happened in the past. Why did you have this cough and cold? Will I be satisfied with all that
No, of course not.
inquiry being made?
Yes, my lord.
What I need is a cough syrup. Give me a cough syrup, and then end of the matter. I get relieved now, and then you can do my examination in the past.
Yes, my lord. My lord, in fact, from the very beginning, when the protest started, whatever the district administration and the police personnel, they are trying to protect the factory, and in fact, on the last occasion, the private respondent, one of the protesters, they engaged a counsel, and he even undertook that he will not engage in this disruption activities. But despite that, there are so many protesters, and when this honorable courts, in compliance of this honorable court's order, when the factory, the petitioners, they were trying to bring in raw materials from outside, this was again blocked by the protesters. In that case also, the district administration, they deployed a large number of police personnel.
Did you arrest any people?
Yes, my lord. We have registered cases, we have arrested, and then even these are in the report. In fact, here we are also trying to protect the factory as well as also try to persuade the protesters not to obstruct. This is what we are
That
trying.
won't happen till the next election comes.
No, my lord. There has been in the subsequent, there is a development that there was a meeting, joint meeting by the representative of the factory and as well as the protesters. And they have come into certain agreement with certain terms and conditions to run the factory.
No.
So that we have
Not
in
correct.
our
In fact,
status.
that is not correct, Your Lordships. What has
No,
happened is.
please please don't interject. The additional advocate general is on legs.
My lord,
Please respect him.
my lord, first, the 489, this is the status report, action taken report by the superintendent of police, my lord, East Siang district.
You
And
see, this action report we have read.
yes, yes.
Here you say that we have done this, done that, we have registered cases. Then you say that we appoint,
Yes.
we put up a platoon of CRPF, and then you say when elections came, they was withdrawn.
yes.
We don't know whether it has been
Then,
back.
then my lord, the next additional affidavit by the deputy commissioner of the district, my lord, East Siang district, that is at page 469.
Well, then you take a very simple plea that
No,
they
but,
wanted to start the operation, the petitioners wanted to start their operation, but they did not start on the appointed date.
No, my lord, what?
That's
No,
that's the report.
not only that, my lord, this is the action taken report,
Page
the page 469.
9.
And then these are what has happened. And then at para 4, at page 470, again on 16/4/2026, meeting was called by ADC Ruxin involving all stakeholders to engage in talks for resolving the issue through democratic participation. During the meeting, it was agreed by local public leaders to consider the operation of the silicon factory. However, it was proposed to conduct a larger meeting by including all the protesters group at so-and-so Dere to convince them and to on the operation of the silicon factory. Minutes of so-and-so, as decided in the meeting dated 16/4/26. A meeting was again convened on 28/4/2026 at Ngorlung Dere, wherein it was decided to allow operations of the Ether Alloys silicon factory with standard terms and conditions. And this minutes of the meeting has been annexed at page 482. This, my lord has seen.
So what are you proposing now?
My lord, we are bound to obey this honorable court's order, and we are bound to protect the factory also. While doing so, will also have to pacify and also stop the protesters. My lord, these are local peoples out there, and that we want to do it in a amicable, peaceful manner, not by retaliation with force. If we be given, if there, as per this minutes, if we be given if they agree, both parties, then it can be peacefully resolved. Some efforts from both sides. As per this minutes, my lord has seen the minutes, my lord, if I may read out, my lord.
The minutes doesn't help.
Yes, my lord, there are,
The order is to be implemented. Second is that the
yes,
operations should resume. Third is that if people start blocking and then if they are adopting measures to cut the road, to stop vehicle from plying,
in fact,
then
they have,
it's not for the court to tell you that even UAPA can be applied.
in fact, they have planted stones, they have, the protesters, they have used machetes also, and
No, you project a picture. You see, you say that in your inquiry, you say that the people were armed, lethally armed with those, all these things. Then they have cut the road. They have stopped the vehicles from plying. Their roads were dug, and it was disconnected. Then you say that there was an agreement that the petitioners would resume their factory.
yes.
Then you also say, because you see, you don't say that the roads were all done and
No,
the
my lord, in fact,
securities were there.
roads were not cut, my lord. These protesters, they blocked the road and then they retaliated the force, my lord, the police
No,
person.
somewhere I have read there was a road cut also.
No,
Then you have said that they blocked the road with tires and they burned the tires.
Yes.
You see, the ingredients of the if you can just find out from the statutes, you'll find that every provision of UAPA is also attracted.
Yes.
The FIRs were there, the inquiry is being made. None of the inquiries are brought to its logical conclusion. And then when the factory is not operating, the deputy commissioner gives a condition that your emissions should not be more than the prescribed level. So unless the factory is run, whether the factory will be emitting pollutants
Yes, my lord.
exceeding the level will only come when the operation starts.
My lord, there is a private respondent here, my lord. The counsel was available this morning. There is a private respondent who is representing one of the protesters, who is spearheading the protest. They
The
also
protesters would
undertook.
be like Medusa's head. You cut one and then 10 people will again come up. So for the purpose of this, they are immaterial. Even if they lodge a protest before the court by way of an affidavit, what will it do? Either you take a policy that will not start operating any factory in the state of Arunachal Pradesh. Take that stand. Buy off the factory and then end of the matter. You acquire the factory and then.
We want the factory to run, my lord.
No, but if you have the will, you will have the way. If you don't have a will, you'll never have a way.
My lord, we want the factory to run and we want to protect the running of the factory and also abide by
You
this
see,
on
you'll
the
have to
court.
just take a resolution in your assembly and tell the court that now you pass appropriate orders for the factory to run, and we'll show you what orders can be passed.
Now, that's
You
why,
see, in one hand, the state government says that the court should not take up the administration of the state. We are only to direct you to take appropriate steps. So you are tying up our hands on one side. And when we pass orders, they are not implemented.
no, my lord, we have implemented, my lord. In fact, we have implemented. There were obstruction, but to safeguard and then everything.
So then you do one thing.
Yes, ma'am.
If you see you say that the police pickets are there.
Yes, ma'am.
You identify people who are creating this and then bring it to the notice, their names and all, bring it to the notice of the court, will drop contempt against them. You have to affix the orders of the court
Yes, ma'am.
at conspicuous places. And then if they still continue with the process, then you'll have to initiate the contempt proceedings.
Yes.
You will have to tell us what to do under these
Madam,
circumstances, because you see, there are two things. Number one, first is the enforcement of the orders. Then second is the enforcement of the orders would also have to mean that the social fabric cannot be allowed to break.
Yes.
We can't allow things like what is happening in one state because of judicial orders. We all know what has happened. And that order was too innocuous order to start that. But people wanted avenue for protest, and they have taken the judicial order of the court to went out. So we don't want to escalate that. Therefore, there are only two things which can be made to take a decision by the state. Number one, James Murditt, we have already shown you that
Yes.
University of Mississippi, 1962.
Yes.
You got it now?
Yes, Lordship.
Now you have got it, huh? Read this. You'll find this this passage of James Murditt very well written in, I think, volume 1 of H.M. Sirvai's book on Constitution of India, Constitutional Law of India. That you will find a very good passage on that. It's worth reading, even if you don't implement that. But please read it. You will come to know. As a young lawyer, also you will know the nature of the respect to the orders of the court that US had done then, 1962, when this was never heard of. At that time, the government came with all force to ensure that the orders of the court was implemented. So we need something from the state of Arunachal also for that same thing. You forget the private respondents and the protests being made. If people will be allowed to take their stand, then they will be offensive of even the black coat we are wearing. They will say this is not appropriate. Wear this clothes, wear that clothes. They will also start dictating which color of coat a professional should wear.
Yes, my lord. My lord may pass appropriate orders, my lord, so that.
Because if you are going by the protests of the people, then why there are what you call appropriate authorities making statements with regard to the recent protests which has happened? There's a protest in Delhi.
Was supposed to.
There was,
I think.
they tried to protest, Your Lordship, but it kind of fizzled out. Hasn't got steam at all.
No, but still,
they did try to-
protest has started.
It was.
If people are granted this leave to take law of their own hands, even you would like to take law in your own hands
Yes, my lord.
instead of coming to court, then we have no respect for the institution.
No, my lord, in fact, strict action has to be taken, my lord.
Categorical
You tell
statement.
us, you tell us, we'll take it up either on Friday or on Monday, whenever you want. You have a discussion, call these authorities and then tell us what you are proposing to do. This inquiry report doesn't help us.
I'll have a word with both.
You lost faith in this inquiries and all because of the fact that number one, it takes a lot of time. Then the inquiries are going on without any, you see, you don't have an,
Without any outcome, my
you
lord.
don't have a goal and then you start an investigation.
Without any outcome.
So therefore, the outcome is not predictable. Third is all these medical, what do you call this, reports which are made. Now the world knows that 150 may not be a, what do you call this, sugar level. Or always 100 plus will not be a sugar level to be alarmed of. So at times, corporates also, or the third parties also influence the reports.
Yes, my lord.
So first of all, you'll have to tell us that how do you envisage to proceed? Number one, whether the district administration is inclined to act in accordance with the orders of the court. Number two, whether you have the otherwise a political will to continue the operations of the factory. That means not lip service alone.
Yes.
Third is, if the protests still come, what is your action plan? You take it from us that they will continue to protest. Then what?
My lord, I'll take instruction. My lord may record my lord's observation so that I can convey it to the authorities and let them have a call. Because, of course, they have to take the appropriate decision how to do it.
You see, there are reasons for us to record a representation. Number one, you depute security at a place X. You depute security. You don't have clarity that if there are protests, then the security people will do what? You don't have. You don't say anywhere that these security people who are there, they have direct access to the district magistrate who can pass appropriate orders at that point of time when the protests have started. Even if they want to do what you call some police steps, they would require order of a magistrate. So you don't say that the police people who are being appointed at the station there at place X, they have the access to officers who are empowered to.
My lord, they are always accompanied by the magistrates. My lord,
that you are not stated anywhere.
My lord, in fact, on the ground, it is with the magistrate.
Ground and then having this. You see, you say that there was a police picket of one platoon. So a magistrate you will not depute for the entire platoon for the entire week to come. A magistrate, if they have to accompany, will accompany for a limited period when you depute them. But this won't be staying. So therefore, if they are not staying and there's a platoon to posted there, then this will have, you will have to say that these people are have to be in contact with the executive magistrates who are empowered to pass appropriate orders to quell the protests. And we can understand if the protest is for something which is otherwise a lawful demand. But under the circumstances, the state has not been able to show that the demand for which the protests are being made is otherwise appears to the government to be lawful. Then, Madam, you have any suggestions?
Please, Your Lordships, in fact, my Lords has rightly observed. What has happened is that on ground, Your Lordships, they're asking us to placate with them, but we are 100% compliant. They're also before NGT. The entire community has gone to NGT. And the matter is sub judice there. And Your Lordship, CPCB has also given a complete report. We are in fact European level compliant here. We are even beyond the European levels. We want to set up an industry which is 100% pollution compliant, my lords. And we are ensuring that. We are even completely assuring them. But despite that, Your Lordships, every day they change the goalposts. They say, now you put a medical force for us, now you do this. And those are all extrajudicial. We are being arm twisted because we are incurring losses, Your Lordships. We came on the assurance, this is an IGC. We came on the assurance and set up the industry here. We have spent so much money and the industry is right now, Your Lordships, for almost a year, we are not able to function. Your Lordship rightly observed that where is the question of pollution, we are not even operating for a year now. And this is in Industrial Growth Center. ECs have been granted. Everything has been taken care of, my lords, to the T. And if there is no investment in Arunachal, how will Arunachal also, Your Lordships, join in the economic growth? Unfortunately, my lords, at the DC level, what is happening is they're bringing both the parties and trying to tell them to negotiate, my lords. And recorded statements made here that they will protest peacefully, my lords, on the side. Both before the Honorable.
Yes, for the private respondent, what do you have to say?
My lords, so, Your Lordships, my lords is asking me.
No, the private respondent is there. What do you want to say?
Private respondent is not here today.
No.
The other one is accompanying. Madam,
I'm not Your Lordship, if you're referring to me, I'm accompanying Ms. Gini Rautre.
Okay.
Your Lordships, at his will he comes, my lords, may just have.
My lord, she is appearing on behalf of.
Yes, what do you have to say?
Lordship, I was only instructed to say that as additional affidavit have been filed, so we need some time to go through it.
No, you see, the requirement of High Court rules is that you will be served with a copy of the affidavit and it will be taken up for hearing after 24 hours, correct?
And Lordship,
This is more than
I was
24
also
hours. You have got
instructed,
it.
Lordship, that copy has not been served, Lordship.
On you?
Yes, Lordship, additional affidavit.
Okay, serve a copy because serve a copy. Otherwise, she has a reason to object.
Also.
My lords, may
But
just.
that's beyond the point. You additional affidavit filed by.
One additional affidavit filed by the SP on behalf status report filed by the SP and the.
Respond number 3. And then respond number 2 and 4, which is the DC, my lords. 2 affidavits have been filed.
2 additional affidavits.
In paragraph 3 of order dated 5th of February, Your Lordships, even the private party has given an assurance that the protest is peaceful.
That's on the side.
You say heard GJ Rotary Learned Counsel for the petitioner. Also heard Mr. N. Ratan, an additional advocate for the state. And Miss
Vaigao Lordship on
Y.
behalf of S.
Gao,
Hirang.
Learned
Yes,
Counsel appearing on behalf of respondent number 5.
Lordship on behalf of S. Hirang, Lordship. My name is not there in cost list, Lordship.
Oh, okay.
Mr. Medhi.
On behalf of Mr. P.P. Medhi.
No, Lordship.
S.
S. Hirang. S. Hirang.
S. Niran.
Yes, Lordship.
S. Riram, Learned Counsel for the respondent number 5.
Yes, S. Ira.
Okay. As Hirang is Y-I-R-A-N-G. Huh? Next one. As prayed for by Learned Counsel for respondent number 5, that the additional affidavit filed by respondent number 2 and 4 and additional affidavit filed by respondent number 3 be served over in course of the day. Next paragraph. The Learned Additional Advocate General has referred to the action taken reports which have been filed along with the additional affidavit. It appears from various documents which have been placed on record through the affidavits filed by the state that there has been a continuous public protest which has prevented the industry of the petitioner to operate. Most of the objections to the operations are by the local people by taking recourse to various ways and means, at times by blocking the road by crowd of persons, by burning of tires on the public road, by blocking the road by public carrying various sorts of arms, It appears from the various action taken reports that the state has also deployed police and CRPF personnel near the factory premises. However, due to the last elections, the CRPF personnel were taken back. Next, according to the Learned Counsel for the petitioner, for more than a year, the petitioners have not been able to operate the factory despite huge investment. She has submitted that the at the time of setting up of the factory, the factory was compliant with Euro pollution norms, which is higher in degree than the pollution norms of the country. Post Office has submitted that the district magistrate have started to call the protesters and the management of the petitioners industry for a settlement at the local for the settlement with the local people. Which is not envisaged because insofar as the pollution norms are concerned, the petitioners have the no objection for operating the industry, and they have also got favorable orders from the National Green Tribunal, correct?
Please, Your
National Green Tribunal. Therefore, it is during the, accordingly it is submitted that it is during the course of such negotiations, that the local people start changing their demands and raising new and fresh demands. For which the negotiations do not come to a logical conclusion. Full stop. Next, the court finds force in the submissions of the learned counsel for the petitioner, because when the matter is in session of this court, it would not be very productive idea to have for the district commissioner to start dialogue between the so-called protesters and the management of the petitioner industry, which appears to have been counterproductive till now. Next paragraph. The learned additional advocate general does not dispute that, as for the policy of the state to promote, and to promote industries, the petitioner industry was allowed to be set up. Most of the state does not dispute that the petitioner industry is not complying with the applicable pollution control norms. It is also not the case of the state that the industry, which has been set up with their approval and licenses granted, is otherwise injurious to public health and safety. Next, therefore, it would be the responsibility of the state and its various agencies to first have a meeting with all the departmental authorities who are concerned with the operation of the industry of the petitioner, with the Secretary to the Government of Assam, Government of Arunachal Pradesh, Industries Department to be the nodal officer to hold such consultative meeting in respect of the industry of the petitioner, which shall be done within the outer limit of 3 weeks from the date of receipt of 3 weeks from the date of the order. First off, we request the learned additional advocate general to send the downloaded copy of this order to the Secretary to the Government of Arunachal Pradesh, Industries Department, Secretary to the Government of Arunachal Pradesh, Home Department. The pollution control will be under whom?
Pollution Control Board, there is
Okay, to the
Member Secretary.
to the Member Secretary, Pollution Control Board,
Arunachal Pradesh.
Arunachal Pradesh. To the District Commissioner, Pasighat East Siang District. The Superintendent of Police, Pasighat East Siang District. To have a joint meeting, either physically or through video conferencing mode, to chalk out a plan for compliance of the orders passed by this court from time to time.
Specific order,
Specifically, the order dated
5th of February.
5th February
5 to
2026.
2026. Full stop. Next para. The court is also further intent to provide that in the event the district commissioner, the deputy commissioner is of the view that he would take the view of the protesters, it would be open to the deputy commissioner, it will be Pasighat East Siang district.
Yes, madam.
To have such meetings as he may be so advised with the protesting groups to find out the nature of their demands. First of how, in this consultative process, the Deputy Commissioner, Pasighat, East Siang District shall not involve the petitioner or any personnel from their management. Full stop. The Deputy Commissioner, Pasighat, East Siang District shall take a call as to which of the demands would be lawful in light of the order dated 5/2/2026, and only those demands which are otherwise lawful and implementable under the norms set out by the state government would only be placed for a decision by the shall be placed before the court. Next para. It is made clear that while the respondent authorities may act in accordance with the directions contained in this order, but it is made clear that this order shall not be treated as in derogation to the directions passed and contained in the order dated 5/2/2026. stop. In other words, the compliance of the order dated 5/2/2026 has not been relaxed by this order. Next para. So 3 weeks will end on
June.
today's 8.
8, 9, 10, 11.
29.
1, 2, 3. 3 weeks will end on, no,
29th.
2, 3.
29th.
29th or 30, whatever
30.
you say, and you'll take some time to communicate.
Yes.
We have the vacations then.
Yes.
You'll we'll first say that minutes to be produced before us. We are dispensing with the filing of an affidavit by the state.
Yes.
So the outcome of the meeting by the state authorities shall be placed before the court in a seal cover on when?
My lord, petitioners, I'll suggest for 21
21.
of July.
Okay. On 21/7/2026. Madam, we have a vacation here. Summer vacation here is from 4th to 19th,
Please, Your
including
Lordship.
Saturdays and Sundays. So 21st, we are fixing the matter.
Please, my lords.
We'll then take a call. We are not relaxing the implementation of the order, but if they can interact, they will find out what are the demands of the protesters. Achha, where we have said to have the demand of the protesters by identifying the persons and groups who are making the demand. Then we'll see. We are taking it in the seal cover. We are not asking for a affidavit immediately.
Please,
We'll
Your Lordship.
see what the nature of demands are and what the state is thinking, and then we'll pass orders. Next para, just before the ending, you say, where we have said that this implementation of the was not. Please read that part. Last part that we have said. Huh? The implementation is not state. That actual language I forgot. We have said that somewhere the implementation order is not
In derogation of the.
is not state, something like that. So just take care of that last sentence. Okay.
Grateful, Your Lordship.
Obliged.
Item number 21 and 22.
Yes.
Lordship, I have filed the IA for vacation of order dated 07/04/2026 passed by this Honorable Court, whereby the petitioner's land has been protected. Petitioner's land, the writ petition lordship has been filed for passing and setting aside of order passed by the Deputy Commissioner, whereby lordship may.
You have filed this IA. Where is the order? You have not annexed the order?
Lordship, I have annexed the order in my counter affidavit. I have categorically made the abatement for allowing me to rely on the affidavit.
You are,
Page
who are you?
I'm Nyai Riva, respondent number 6. Page 92 is in my affidavit.
Where is the notice dated 31/3/26 in the writ petition?
Page 18. In writ petition, page 18, annexure 3.
Page number 18.
Yes, Your Lordship. This is the Your Lordship eviction order, eviction notice passed by the Deputy Commissioner.
You have a copy of the plaint with you? You say that you filed a civil suit.
Civil suit, yeah, petitioner.
Who has filed the civil suit?
Petitioner. Lordship, may I be allowed to submit only 5 minutes? I'll demonstrate how they are using this interim order as a tool and license to demolish and my property. I have annexed the photo and I have complained before the authority. What they are saying is, since there is interim, we cannot do it. The day when they obtain this interim order, even what they have prayed is for setting aside and passing of the order dated passed by the Deputy Commissioner. But this Honorable Court has not even stated order, the notice passed by the Deputy Commissioner. What Honorable Court has said is, if the petitioner has the land, LPC land, his land should be protected, that much. Then he obtained this interim order, and this interim order has been served to me personally by him. The day when he served to me, that day, overnight, he has demolished my pension, my...
No, you see, for that you don't file in your application for modification interim application. You don't file you do not said that you have filed an FIR before the police. Even that is not there.
I have categorically stated, and I have annexed in my counter affidavit.
No, but you see, when we are looking at the interlocutory application, why you want us to look at the counter affidavit again? Which page is that? FIR.
FIR is the complaint before DC is at page 97, and 98 is to DLRSO, 99 is to OC, officer in charge, Likavali. And prior to the pages are the photographs.
Just a moment. You have a copy of the print? You filed a
of
civil
the
suit. Do you have a copy
civil
of the
suit-
print?
No, Your Lordship, I don't have the copy.
Lordship, may I submit Lordship, even in the title suit,
You see, we don't have a copy. We're asking for a copy. You don't even give the copy. Then you are arguing about.
Lordship, they have filed objection against my implement application in the title suit. They said that lane is nowhere connected, and accordingly, learned the civil judge. Senior
Those
division-
matters are not before us.
No, Lordship, I have annexed the order. Order passed by the learned civil judge, senior division, Pasigat.
Which page? With those things you don't file in your IA.
77.
When you are filing an IA, we look at the IA. Why should we look at your
There is nothing annexed in
reply here?
Lordship, since I have to rely on the same fact.
No, no, no. When you're filing an IA, it should contain everything. Are you expecting us that we will not find here and then go to affidavit and then read and then come? Is that your expectation?
Page 83. Lordship.
83.
Yes. Even in that, after obtaining the injunction order, he has misused. Therefore, I have annexed entire sequence of the events. How the petitioner is intending to misuse the court order after obtaining the not only court order, even the authorities, Deputy Commissioner.
Your Lordship, in the second last para, it is clearly mentioned here that the land of the applicant covered under LPC so and so, dated 6/12/2030, is not the suit lane in the title suit number 21/2023.
That is what I am submitting because this my suit lane is the lane is nowhere connected to the suit lane pending before the Pasigat. Earlier, Lordship.
So you are saying that he is taking this order and he is demolishing your properties?
Yes, earlier. Subsequently, after passing of this order, Deputy Commissioner has interfered because he was completely demolished and changed the structure, demography of the land. Then Deputy Commissioner, he interfered. He has passed the order, but then again he was continuing. Then Deputy Commissioner deployed the force to stop him from further construction. I have annexed the photographs. Lordship, may just page number 80 is the photographs whereby even to the extent of deploying the force, he has carried out activities. Then after detailed demarcation, spot verification, Deputy Commissioner has passed this 31 order, which is impugned in it, saying that because my land was earlier, I had a land, private land. That land has been utilized by the BRO, the government agency. Against that land, I have been given this land. So after again, when I start developing my land, then again he challenged this order before this honorable court and obtained the interim order. Again, he is using this as a license. However, in the order, there is not even remotely mentioned about to grant him to demolish my property and all. Lordship, may I just submit a sequence of fact, just in 2 minutes? Lordship, page number 67 is the order passed in the title suit, whereby he has claimed that the land, because earlier Deputy Commissioner, he ordered for spot verification of my land. And in that, while carrying out the spot verification, what the petitioner he submitted was the land is already, this disputed land is already.
You see, you're saying everything, but to me, it's very difficult to understand. Who is the defendant number one against whom these orders are being made? You don't give us the copy of the plaint and then you make submissions on that. How will I understand if we don't have the, we have not read the proceedings of the suit? You have a copy? No.
No, Your Honor.
Then we'll pass our order that you will not disturb the position of the respondent number 6.
Yes, Your Honor, Your Lordship, the status quo may be maintained, Your Lordship. Let the
No, you not disturb it. There's a positive order not to disturb his position.
Because Your Lordship, as per their allegation, but Your Lordship, this land was, I have obtained LPC on this land in the year of 2016, Your Lordship.
Then you had no business to get a second LPC in 2023.
Because the LPC they are obtaining is obtaining is, Your Honor, the overlapping over my land, LPC land, Your Lordship.
No, then that will be inquired. You have not asked for inquiry by the Deputy Commissioner. Have you asked for the inquiry?
We have already, Your Lordship.
That inquiry appears to have been made in the impugn order.
Your Lordship, regarding that, we have already written to the Deputy Commissioner for cancellation of the LPC, Your Lordship.
It has been cancelled. It is rightly so then. That is after the cancellation was done, after making an inquiry, this page 17 order, sorry, the 18 order.
For the eviction, Your Lordship.
Yes.
Yes. Your Honor, this eviction was served upon my tenants, Your Lordship, who are staying there since 2017, Your Lordship.
You see, your first case is that he is not the occupier of the land, and therefore you object to his pleading in the suit.
Yes, Lordship.
Correct. Therefore, you have no business to disturb him.
We are not disturbing, Your Lordship, because I am whatever I'm doing in my lane only.
Then you have got nothing to worry about if you're not disturbing him.
Yes, Your Lordship. So, Your Lordship, I will. My humble prayer will be, Your Lordship, let the maintain status quo, Your Lordship.
No status quo. You'll not disturb
Your Lordship, because Your Lordship, I need some time to take instruction on this, Your Lordship.
What is
to file
status quo?
reply on the IA, Your Lordship.
What is you reply? But what is status quo? You can't enter into his land and then say status quo.
Regarding that, Your Lordship, I have to take instruction from.
You take it.
Or I need some time, Your Lordship, to reply this IA, Your Lordship.
In the meantime, we are staying it. We issue notice, and in the meantime, we are asking you not to do it.
Because Your Lordship, if this interim.
You see, we asked you 3 times. You don't have a copy of the plaint. You are relying on it.
Yes.
What is the nature of your suit? We don't know. He's claiming he's given photographs saying that you are demolishing his property.
Yes, Lordship. Because your the title suit is pending before the.
He's not a party there.
Yes.
Exactly.
He's not a party. You have challenged his locus standi saying that he is not the authority over that land. You say it's a different land, and he has come to protect his land.
Because, Your Lordship, here I am challenging only this impugn order dated this eviction notice, Your Lordship.
That's why he has rightly come.
Because, Your Lordship, if this interim will be
Orders of the
vacated, then.
court, you can't demolish his property.
Yes, Lordship, because if
Can
this.
you demolish his property?
No, we are not demolishing, Your Honor. Because,
Then
Your
you have
Lordship.
nothing to worry about.
Because
Why are you worried?
Because, Your Lordship, this impugn order this eviction notice was passed against me, Your Lordship. If the interim order will vacated, Your Lordship.
We're not
then the
vacating the
very
interim order.
purpose.
We are giving a positive direction. You will not disturb him.
Yes, Your Lordship.
Lordship, that way, that may not serve, because he has already demolished, and authorities, what they are saying is, since there is an interim order protecting his land.
We are not disturbing the interim order.
Interim order is in favor of the petitioner.
You want to protect your land. We are not vacating interim order without hearing. You file your affidavit, you have already filed your affidavit, will hear the matter. Interim order we are not vacating. You said that you are aggrieved. You just now said what? You said that you are aggrieved because he is demolishing your property.
Yes.
How can you have more protection than what you are aggrieved by?
What?
No, what the authorities tell, we are not to listen to them. We are implementing our orders. We are trying to protect you. If you don't want protection, tell us that we don't want that protection. Then we'll understand that your interlocutory application is without any merit. What the authorities think, what the authorities advise, we are not bound by that. Have you disclosed the name of the person and the date on which he gave you that advice?
Lordship, whenever
Then-
the court order goes to the
No.
office.
No. Everybody knows what they want to
Because
do.
I have filed series of complaints. In previous occasion also when he obtained the injunction order, then also he said, no, we cannot enter into this because this is a court order. Now also they are saying the same. And in that pending title suit, I filed implement application saying because the petitioner was taking shelter of the court order.
You see, we have got many answers. One of it would be that the issue raised is a pure question, dispute question of facts. We don't entertain, you go to the civil suit and file a civil suit. If you want that protection, you better go there. If you want things to be handled in a simpler way, we are doing it. But if you are making things complicated, do you think that the court will now try to find out who is in position, who has got the right title interest, and then pass orders in a writ court? No, we are not doing it.
But Lordship, I'm just submitting that he has not come before
That
the
is-
court with the clean hand because
That is why we are saying that if you are with clean hands, you go to the civil court, you file a suit for declaration. He says that there is a LPC and there is an encroachment of the LPC. The LPCs are overlapping.
Yes.
It becomes a dispute question of fact.
So that has been, that is the reason why Deputy Commissioner has, because pursuant to the learned civil judge order, they have demarcated my land. In the order, it is clear finding that petitioner has encroached my land.
No, the order doesn't say so.
Prior to that,
Then prior to that,
no, I have annexed the order.
you see, that's why we are trying to again tell you. You amend your application, you file a better application. If you want us to read this, we are not reading part of the application here and part from there. If you file an affidavit, then we'll hear it. If you want us to modify the orders, then bring everything here. We are not for the interlocutory application. We are not we are not reading this. You did not put us to notice that in the documents, in this document, there are no document, and therefore you are relying only on your affidavit. If you are wanting a protection, we'll give it. We are not vacating the interim order. Heard, Mr.
T. Pumbo.
No, your name? R. Koel, learned counsel for the applicant. Also heard, Mr.
T. Pumbo.
T.
Pumbo, Your Lordship.
Kumbok, learned counsel appearing for the opposite party. First of the opposite party is the petitioner in the connected WBC 152 APO 2026. Next paragraph. By filing an application on Article 226 within bracket 3 of the Constitution of India, applicant who is the respondent number 6 in WBC 152 AP of 2026 has prayed for modification of the vacation of the interim order dated 7/4/2026. So it is projected that after obtaining the interim order dated 7/4/2026, the opposite party make it the respondent number 1 the opposite party number 1 has misused the said interim protection and by taking law into his own hands, has demolished the bamboo fencing and damaged the temporary structures on the land which the applicant claims to belong to him. Next paragraph. Issue notice returnable on, give a date after 2 weeks, returnable on so-and-so.
5 July.
No steps are required to be taken as all the respondents are represented. All the opposite parties are represented. Next paragraph. As an interim measure until the next returnable date, it is the opposite party, number 1, within bracket rate petitioner, is prohibited from demolishing any structure in respect of the land of the applicant, which is covered by LPC. Where is your LPC number? LPC number DC/LSD/LM/GREF/2020-21 within bracket part bracket close /536 dated 6/12/2023. This is in paragraph 6. Next paragraph. This interim direction is subject to further orders that may be passed on the next date of listing. Next paragraph, list on.
Lordship is insisting for 26 July.
Huh?
26 July.
26 July, okay.
26 June or July? June, 26 June.
And in the main case, you say that in view of the order passed in IA Civil 114 AP of 2026, list on so and so. Just a moment. In the IA, you also say that as the order is being passed in the presence of the Learned Counsel for the respondent number 1, opposite party number 1 within bracket writ petitioner, comma, the order would be effective from the date of the order. So accordingly, the Learned Counsel for the opposite party number 1 shall transmit a downloaded copy of this order to bring it to the notice of the opposite party number 1 within bracket writ petitioner.
Item number 23 and 24.
Yes.
My lord, this is regarding impletement of an additional respondent who is a necessary party in the matter, my lord.
You want to impede somebody as respondent number 17?
Yes, my lord.
Tell us why you are wanting to impede the person by name.
My lord, because in this case, there are allegations of fraud against him. There's a matter of false evidence. He was the former ADC. So during the administrative processing of vigilance clearance for my DPC, he came up with false evidence, which was later used in this honorable court. So therefore, a relief has been claimed against him. So that's why, my lord, his implementation is necessary.
Yes, Your Lordship. Yes, I have no objection, Your Lordship.
Okay. But the petitioner in person.
And my lord,
if you kindly permit, and I want to raise some urgent questions. Urgent matter.
You want us to pass orders in your interim application, or you want us to argue, you to argue in the main writ petition?
My lord, for better perspective, I want to apprise you that.
No, we are not hearing stories. You want us to pass orders in IA for implement. For that is what you are going to submit, is it necessary?
No.
No, then please don't do it. Petition person and Miss
P. Sangeeta, Your Worship.
Miss
P. Sangeeta.
Sangeeta, government advocate appearing for the state respondent numbers
127.
127. Next para. The petitioning person submits that there is an allegation of fraud against the respondent numbers, fraud committed by respondent number 17 in the writ petition, and due to inadvertence, the respondent number 7 was not implemented in the writ petition. So accordingly, he prays that the opposite party number 17 who has been left out be implemented as respondent number 17 in the connected WBC 222 of 2026. Next, you have the statement made by the petitioning person, comma, the prayer made in this interrogatory application stands allowed. The opposite party number 17 is permitted to be implemented as respondent number 17 in the connected WBC 222 of 2026. The applicant shall file amended cost title in the in WBC number 222 of 2026 by handing it over to the registry for being incorporated in the writ petition and for consequential amendment to the CIS data. In writ petition, you say, heard so petitioner in person in view of the and Ms. P. Sangeeta and government advocate appearing for the respondent numbers 1, 2,
7, Your Worship.
7.
Your Worship, may I pray that 3 weeks time may be granted, Your Worship, since we have not received the Parawest reply.
Okay. Next para. In view of the order passed today in IA Civil 118 AP of 2026, by which impleading of respondent number 17 was allowed. First of the pending filing of the amended cost title by the petitioner in person within 2 days, the court is inclined to issue notice on respondent number 17 by speed post with AD. First of the petitioner in person is permitted to collect the postal receipt number and to submit postal track report prior to the next date of listing. Next para. The petitioner in person is also permitted to collect the postal receipt numbers in respect of notice issued on respondent numbers 8 to 16 and to submit postal track report prior to the next date of listing. Next para. On the prayer made by government advocate, 3 weeks time is granted to file affidavit in opposition in the matter. What is your instructions on that non-compliance of KV Janki Raman and that not to open the seal cover procedure? What is your
Your
instructions?
We have not received any instruction, Your Lordship.
No, but this instruction you should have received. This order was passed on 19/5.
I'm sorry, Your Lordship, because the conducting counsel was a different government advocate, Your Lordship. The case was conducted by the different, another government advocate, Your Lordship.
Is the inquiry against you over?
It's pending, my lord. My lord,
If it is pending, then there's no violation of KV Janki Raman.
no, my lord. KV Janki Raman, it says that at the time of sitting of the DPC, even article of charge is issued, then only it will attract. Whereas in my case, my lord, the DPC was already held on 24th August 2023. Then a year later, article of charge was issued, and that too for my lord going on medical leave. So that will not attract, my lord, because that is the precise statement of KV Janki Raman. And after KV Janki Raman, my lord, there are two subsequent Supreme Court judgments which affirms the settled law of KV Janki Raman. And my lord, may I
Is the next DPC due?
my lord, the next DPC has already been circulated on 20 November 2025. Now, basing on the earlier illegal seal cover process, I've been left out from this ensuing DPC also. So, my lord, my humble submission is the state is not in emergency. My lord, to put the things in better perspective, I'm a person with multiple disability. I have a benchmark disability of 89.9%. Now, coming to the section 3, 5, and section 20 of the RPWD Act, my lord, the state cannot put artificial barriers to discriminate against me in matters of employment. My lord, there are two binding Supreme Court judgments in the matter. So, my lord, my rights are protected under Article 21. Now, my lord, my humble submission is, my article protection under Article 21 cannot be put under suspension for years together, my lord. Rather, state has a mandated duty to clear administrative barriers so that I can equally participate in the matters of employment in social transactions. That is why my humble submission is, my lord, kindly my interim prayers may be considered, because this court has the extraordinary power to pass any order in the interest of justice.
Next, the learned counsel, the petitioning person projects that when the previous DPC was held on, what is the date?
24 August 2023, my lord.
24 August 2023, comma, no article of charges were served on the on him, and the articles of charges were only served on the on him on
my lord, it was in September 2024, a year later.
Sometime in September 2024.
Right, my lord.
Or 25.
24, my lord. DPC was held on 24th August 2023.
Okay. September 24. So accordingly, it is submitted that now after the articles of charges were submitted, comma, the name of the petitioner, his name is dropped from being considered by the fresh DPC. Next paragraph. In view of the statements made, comma, the learned government advocate shall obtain instructions as to why the name of the petitioner was not placed in the previous DPC, which is stated to have been held on 24/8/2023, which is stated to be before articles of charges were actually served on him. Next paragraph. Next, the learned government advocate shall transmit a downloaded copy of this order to obtain instructions. In the meanwhile, the respondents are also granted 2 weeks' time to file affidavit in opposition in the matter. Next, in the meanwhile, as if the petition is otherwise eligible to be considered for is within the zone of consideration for the ensuing DPC 2026. The state respondents shall provisionally include the name of the petitioner in the zone of consideration.
Your Lordship.
First of all, if the petitioner does not fall within the zone of consideration, it would not be necessary for consideration of his name for the ensuing DPC 2026. Next, list on, give a date after 2 weeks.
3rd July.
3rd July will be just prior to this vacations, not that. Make it 30 June.
30 June.
30 June. Next part, the petitioning person will produce a certified copy of the order before whom?
Pardon, my lord.
This order will be produced before whom?
Your Lordship.
Department Secretary?
Yes, Department Secretary, Your Lordship.
Ma'am, 30 June.
Secretary Personnel.
Next step, please.
Secretary Personnel, Your Lordship.
Secretary Personnel.
Yes, Your Lordship.
For the Secretary within bracket Personnel, Government of Arunachal Pradesh, within bracket respond number 4. Okay.
Your Lordship.
Much obliged, my lord.
Your Lordship, the instructions also have to be produced on next day, Your Lordship.
Yes.
On 30th.
Because his specific cases that the DPC was on the date the DPC was held, he was not served with the article of charges. So if not, then why his name was not considered? That instructions.
All right.
Apart from your affidavits which is being filed, these are the specific instructions we need.
Okay.
And if you want to answer that, you can state in your affidavit, then these instructions would not be necessary.
Okay.
But if for some reason you are not filing your affidavit even on that day, then this instructions. So number 1, you can have this incorporated in your affidavit.
Yes, sir.
Number 2, if affidavit is not filed, then these instructions must come. Okay.
Obliged.
Much obliged, my lord.
Item number 25.
My lord, this case has listed.
Lordship, I've taken steps on respondent number 6 and 7.
My lord, I beg to appear for respondent number 6 and 7. I would request for some time to file my reply, my lord. There are some documents which have not been placed before your lordship. some very crucial documents. The major part of the contract has not been placed before your lordship, which contains an arbitration clause. Most of the communication has not been placed before your lordship, which shows that the work was incomplete.
It's okay, unless we
Rectifications were
have it,
not
we
done.
can't make any comment, you file it.
Please, Lord.
By when you are filing your affidavit?
My lord,
When you
your
are
lordship
filing
may
for
kindly give me 6 weeks, my lord, because the respond number 6 and 7 is a central government enterprise, and the new CMD has just been appointed last week.
But what is this CMD has to do with the nature of prayer made here?
No, Lord, I'm just saying the response, etc., everything, it has to be sent up to the ministry for comments. It takes some time, Lord. That's why I was requesting for 6 weeks.
My lord, in this case, I'm appearing for respondent number 125, my lord. I also need
125.
4 weeks time for filing my affidavit in opposition. FCI respondent.
Okay. Your name?
May give 4 weeks time, Your Lordship.
Your name?
G. Kato.
G?
G. Kato, Your Lordship.
Learned Counsel for the petitioner. Also heard Mr. BK Singh, Learned Counsel appearing for respondent numbers 125. Full stop. Mr. Your name?
Gaurav Gupta for respondent 6 to 7.
Gaurav Gupta, Learned Counsel, enters appearance through video conferencing mode for respondent numbers 6 and 7 and prays for time to file his wakalatnama as well as the affidavit in opposition. You want to file an affidavit? No.
Yes, I also need 4 weeks time, my lord.
Okay. Similarly, the learned counsel for respondent numbers 1 to 5 also prays for time to file affidavit in opposition in the matter. Next para. The affidavits shall be filed by, give a date after 4 weeks.
22nd July?
23.
2nd July.
2022, 7, 2026. Stop. List the matter for further consideration on 27, 7, 2027. Affidavit shall be filed by 22nd. You're taking it
22nd,
up
my
on 27th.
And my lord, next day on 29, my lord, instead of 27. Another case
29th.
has been fixed.
Okay,
29 July.